Item 801.
Yes, no, it is mentioning actually this is a bail matter in which we have been in custody, and every time it has been there deleted. So it will not be deleted.
Wait, is it listed?
8th August.
Not to be deleted.
Okay, but
Item 802.
Yes, Your Honor. This is a transfer petition. I am requesting for listing of an IA for seeking stay, Your Lordship. The reason is that the trial, before the trial court, the matter is coming up on 1st of September.
Some date in August.
I am grateful.
The matter is what is the matter? It is on 13th of August, my lords.
Which case?
Balaji Mandir Punch Committee versus Purushottam and others. I am appearing on behalf of respondents.
No, which matter?
Yes, I am mentioning.
Oral mentioning or listed mentioning?
Unlisted mentioning.
My lords, I have also moved an email for mentioning my lords.
Sorry, unlisted mentioning you don't mention.
My lords, kindly allow, I have moved in 4 days back. My lords, the respondents are taking petitioner taking third party interest, my lords.
Thank you very much, sir. We don't entertain unlisted mentioning. For that, you have to go before Honorable the CJ or as per the procedure.
Yes, my humble request is that I have.
Thank you, gentlemen.
Item 1. Rudy is your lordship.
My lords, I am appearing for respondent 2 accused in this matter, my lords.
My lords, I am appearing for respondent 1 state.
You have moved
For the
an application for adjournment.
My lords, I have moved objection to that, my lords.
We have seen
the
that.
reason being, my lords,
Because the trial court is not proceeding with the.
my lords, not the trial court. There is one connected offence under Gangsters Act. I have been granted bail in all other matters. Now, in this offence, my bail is pending before High
We have
Court.
seen that.
And I would be otherwise statutory entitled for bail under 436A of CRPC because I have been in custody for more than 6 years. And under Gangsters Act,
You are, gentlemen, please proceed to argue.
my lords, I will assist.
Argue.
My lords,
Argue your matter.
my lords, I will assist. Now, my lords,
Argue your matter.
my lords would kindly see there are 15 witnesses. I am assisting my lords on merit only. My lords.
Even what we are saying is, please proceed to argue your matter.
My lord,
Because,
my lord.
see, we are opposing his adjournment.
Indeed,
We are disallowing his adjournment.
my lord.
Now, bail has been granted to 302 matter.
My lords, please.
Let us proceed.
My lords, may kindly have.
Whether the correctness of the order is an issue.
Indeed.
Proceed.
Now, my lords, may kindly have my counter for a moment. There is the chart of cases.
We are not going into the counter.
My lords,
We have seen the counter.
my lord, there are 3 grounds primarily on which my friend has moved for against that order. First, he says about pace of trial. Now, my lords would see.
Kindly come to page 6 of the counter.
My lords.
Counter of respondent number 2.
My lords. Great, my lords. Page 6 has the para 15 has the chart. One, I have been acquitted.
Correct.
My lords, in 4, I have been granted bail.
So.
5th is this case, which is before my lords. And 6th is that Gangsters Act.
So.
Now, my lords, may kindly see.
Tell us why should we not cancel your bail?
Now, my lords, may kindly see there are 55 witnesses. There are 55 witnesses which are to be examined.
Correct.
As of now, only 15 witnesses have been examined.
13
Last
13 or 15, whichever it may be.
They say 15.
Well,
Court order says
No
30,
problem.
but in the meantime, I believe 2 more witnesses have been.
Yes.
So 15 out of 55 in last 6.5 years.
Yes, please.
Now, my lords, may see the complainant. Now, complainant in this very case has named some people in the FIR itself. Now, in that case, eventually closure has been filed against those accused persons, and complainant is alleged to have forged the document of court record wherein he forged the affidavit and court has proceeded to take action against him.
He may be
for
a rogue.
implication.
He may be a rogue.
My lords.
Gentlemen, he is a rogue.
My lord. My lord, now I am not present at the spot.
We are not examining
My lord.
his locus.
My lord.
He is the complainant.
My lord.
He is a rogue.
My lord.
Whatever wrong he has committed, the
My lord.
law would take course.
My lord.
Correct.
My lord.
We are into the bail correctness of the order of
My
bail granted.
Now, my lords, may kindly see the reasons which have been given by the High Court by granting bail. One is the slow trial. My lords, would kindly have the impugned order for a moment.
We have it.
My lords. Now, there are reasons which have been specified. First is that the trial is proceeding at the snail scale. It says that 13 witnesses. Now, my friend says 15 witnesses have been examined out of 55.
We will only
Now-
want you to do one thing.
High Court also says,
Gentlemen, just
my lord,
we will only want you to read the 4-page bail order.
my lord,
Right,
my lord,
right
great,
from the word,
great,
right from the word. Judge, you need the name of the judge.
my lord,
This is the first bail application.
Great.
Now read till end.
grateful, my lord. By means of bail application, the applicant has praised to enlarge on bail in crime number such and such. The bail application of the applicant was rejected by Learned Trial Court on 9/10/2023. The following arguments made by such and such Learned Counsel on behalf of applicant, which could not be satisfactorily refuted by such and such Learned Counsel for the informant. And Sri such and such Learned AGA from the record entitled the applicant for the grant of bail. 1. The applicant was not named in the FIR or in the statement of first informant. 2. The principal offender to the contrary have been nominated in the FIR. 3. Prosecution case does not attribute the role of shooting at the deceased or to the applicant. 4. Role of the criminal conspiracy has been assigned to the applicant. Prosecution evidence does not connect the applicant with the offense of conspiracy. 5. The applicant is a law-abiding citizen who cooperated in the investigation and has joined the trial proceedings. The applicant never tampered with the evidence nor influenced any witness. 6. The trial is moving at snail's pace and shows no sign of early conclusion. The applicant cannot be faulted for the delay in trial. Status report sent by the Learned Trial Court in the bail application of co-accused records that the prosecution proposes to examine 55 witnesses. However, only 13 witnesses, including material witnesses, have been examined. Learned Counsel for the applicant calls attention that the witnesses are not cooperating with the trial proceeding. Clearly, the prosecution witnesses are delaying the trial only to prolong the incarceration of the applicant without there being any evidence against them. Inordinate delay in concluding trial has led to virtually an indefinite imprisonment of applicant without there being any credible evidence to implicate him in the offense. The right of the applicant to speedy trial has been violated. Learned Counsel for the applicant claims congruency in role and seeks parity in relief granted to co-accused such and such, having been granted bail on such and such. The applicant has explained his criminal history. It is also contended that the applicant has become a soft target and a convenient scapegoat for the police authorities who nominated him in a number of false cases to burnish their professional credentials. The said cases do not have any bearing on the instant bail application. The applicant is not a flight risk. The applicant, being a law-abiding citizen, has always cooperated with the investigation and undertakes to cooperate with the court proceedings. There is no possibility of him influencing witnesses, tampering with the evidence, or re-offending. In the light of preceding discussion and without making any observation on merit, the bail application is
Now we put it to ourselves.
my lord.
The tripod test has been dealt with it by the judge at all or not?
My lord.
Number one. Number one.
My lord.
Number two. Kindly come to page 13.
1-3, my lord.
Yes.
Great.
Ground G.
My lord, ground G. Because the Honorable High Court heard in observing that accused number 2 is a law-abiding citizen who cooperated in investigation and had joined the trial proceeding. To the contrary, the Honorable Court...
Read slowly now.
I'm sorry. To the contrary, the Honorable Court has been misled as the accused number 2 was absconding. Non-bailable warrants were issued against him
Now, is it
and
correct?
he was declared a proclaimed
Is it
offender.
correct?
Now, my lords, FIR...
We are
is
only
not
asking
approval.
you.
My lords, I am answering that. I am explaining it.
1 minute.
My lords.
NBWs were issued against you.
Yes.
Your absconding.
Yes.
Bounty of 25,000 was declared.
Yes.
And it was only after rigorous effort that has been finally arrested from
My lord,
Kolkata.
October is the FIR. December I have been arrested. 60 days. Within 60 days, my lords.
One minute.
I was up, my lords, in the process. I was.
Did you disclose this fact to the honorable judge?
My lords, this was. My lords, I'm sorry. I
Did you
am
dis-
failed to understand.
Did you disclose this fact in your bail application?
About my lord.
About this grounds you?
My lords, I have. My lords would kindly see. My lords would kindly see. Being absconding or issuing of non-bailable warrant would come in my way when it comes to anticipatory bail. My lords, I am in custody for last 6.5 years.
state, my lords, and he is actually a history cheater, implicated in many
And we'll hear you later.
My lords may see
For this court, none has any problem or issue of not being heard. We will not allow this interjection. Because had you been so concerned, you would have been standing on this side rather than.
Supposing, my lord, I have written that I am seeking time to file the counter.
We are saying you would have assailed the order of bail had you been so concerned. That's what we are saying. Nonetheless, we'll hear you. Don't worry. Don't worry.
My lord.
Now, our query to you is read ground G and H, please.
My lord. H. Because the Honorable Court has.
Because your co-accused have also been absconding.
My lord,
Trial has not been progressing.
in fact, those who have been granted bail, he does not challenge those bail orders.
2018 FIR, the trial is not progressing only because of your reason.
My lord, I am in custody, my lord.
Gentlemen, you and your co-accused.
My lord,
And
there is
therefore,
no
you
evidence.
say that because of the time lag, grant me bail.
My lord, there is no evidence
Very much.
connect
Want to
with
give your
that.
written submissions, please give your written submissions.
My lord, I will do that.
Heard. CAV and counsel for the parties are permitted to file the written submissions within 2 days.
If I may,
My lords,
So London Amicus says.
my lord, my report is there.
What do you say?
Your lordships appointed me for responding.
We know that you're Amicus.
Your lordship, the rigors of cancellation of bail as set by this honorable court are a little strict. I've highlighted all the orders.
So, no, what is your view?
Your lordships,
As an Amicus, what is your view?
cancellation of bail, your lordships curtails the liberty of an individual, your lordships, and it can only be exercised in extreme cases. Your
So, in this case, what is that you say the court?
lordship,
should do?
my preliminary submission is that he is not been named in the FIR, your lordship.
Okay.
And as per the complainant only, it has been his statement has improved because after filing of the FIR, when he gives his statement, he says that the deceased before dying took my name.
Okay.
But the same has not been mentioned in the FIR. You know.
Very good.
So that is.
State what you say.
my lords, I really need time to file counter.
Then we are
Yes,
going
my
to
lords.
give your written. Thank you. Give your written. It said written submission within next 3 working days. Okay.
Great.
Both these matters, Manoj, the respond number 2, Manoj. In fact, the accused.
What rejoinder is required?
Manoj, they had filed, Manoj, the counter has been filed by the state, Manoj. Only yesterday, Manoj, 2 days back, Manoj. And both the accused are, well, I'll not press on that, Manoj. In fact, Manoj, the accused, Manoj, they have not been served, Manoj. That is the office report, Manoj.
The accused have not been served.
Manoj, at the given address, Manoj, both are not available.
Service not complete.
Service may be directed to be effected through SHO consent.
Yes, Manoj.
Respondent, as per office report, respondent number 2 could not be served. Service through SST.
Yes, Manoj. In both the matters.
SHO may do.
No. SHO, you said earlier, you are the state. Go there.
Oh, right.
Lord was pleased to grant that the counter is there, but Nikki Jaiswal,
You just pass it over, someone may come.
please,
You just pass it over.
please.
Item 4.
Petition has been already been.
Just 1 minute, sir. Service is, what do you say?
My lords, I appeal for the state, my lords. My lords, I wish to place on record the statement of the victim categorically naming the petitioner herein, my lords.
August 24, now we can.
Yes. My lords, there is also a discharge application which has been filed by the petitioner.
We can't and wait.
Right.
Wait.
Lordship, the only problem is that despite owner of the Iowa vehicle and the owner of the stone crusher plant has been granted anticipatory bail, the driver has been granted anticipatory bail, my lord.
He is not joining.
No, my lord.
If he is not joining the investigation,
Mr.
Lordship.
Counsel, Mr. Counsel, Mr. Dwivedi, just 1 minute. He's still on the mistakes.
Okay, Lordship. Okay.
Well, while the anticipatory bail was
We know that the
before
driver,
Jamshedpur
we know that the driver and the mine owner has been granted bail.
Well,
I could ask you to surrender.
Malad, on
Why is it that you have not surrendered?
Malad, on 15/5, I appeared.
Have you joined investigation?
15
No, Your Lordship.
2024, I joined when I got the application for 41A. I joined the investigation.
After we granted order, have you joined investigation?
No. Day before yesterday, I got the instruction that he went to the concerned IO and he also asked for a proper.
Okay. Yes, Mr.
Lordship,
Dwivedi.
Lordship, if you had page 6 of my reply, I have categorically stated 41A notice was served on him to appear on 5th May and then on 30th July. On both the dates, he has not appeared.
Nahi. See,
The last thing on 30th July, day before yesterday.
Sir, Mr. Counsel,
Lordship.
your counter, ma'am, talk.
We're saying,
You do one thing, file a rejoinder and immediately report.
Malad, I will join the investigation and file a response.
Petitioner shall.
No, there is allegation against you that despite you being informed by the IO to be present, you have not attended.
That is what I am putting on my lords. That day before yesterday, he went to the IO and he even asked that some.
When
granted to
when
him that he
IO
has been present.
when IO is giving you notice, summoning you, you are not appearing, and someday you are approaching yourself without being invited.
Earlier once I appeared.
When you say that when I went, they didn't.
2024 I appeared, my lord. I'm willing to appear. I'm willing to.
Petitioner shall make himself available before the concerned IO on tomorrow at 10 a.m. The police station, which is the police station? Concerned police station at 10 a.m.
Azad Nagar.
In the meanwhile, rejoinder be filed within 1 week, list on dash.
Okay, Lordship.
Right.
Item 6.
Tomorrow and all subsequent dates as he may be required during the course of investigation. And we'll confirm. We're confirming the order. Same order. We're confirming the ABL order.
Item 8.
8, same.
Much obliged.
Item 9.
For petitioner 9, my lord.
Yes, please.
Say 69-year-old lady, my lord.
NBWs have been issued against you.
My lord, she is 69-year-old.
NBWs have been issued or not is what we are asking.
My lord, I am requesting.
The High Court says that.
My lord, High Court says that, my lord, prosecution get against every accused in 15 days or in 20 days NBWs, my lord. My lord, I am requesting only she is ill and 69-year-old, my lord. And my lord, who sued the lady is not related to petitioner, my lord.
Gunshot injury है.
My lord.
Gunshot injury है, NBW है. और tell us.
My lord, is the neighbor, my lord, who is sued?
The FIR. Gunshot injury. You on your behalf and on your asking, the gunshot was
my
fired.
lord, who fired the gun, my lord? He is the neighbor of the complainant, my lord.
You satisfy us on 2 things. Content of the FIR, alleged allegation, and that you have been absconding, NBWs.
Well, allegation due to my lord matrimonial dispute, she is making
Only because you are a woman doesn't make you entitled for a bail. It's the case of
my lord, they want extra money only due to that falsely implicated in FIR, this FIR, my lord.
allegation. It's categorically against you.
My lord, only I was not there, my lord. My lord, I was not there and I am old lady, my lord.
How old are you?
69.
You are aged, infirm.
69-year-old and ill, my lord. So, my lord,
You do one thing, you surrender and we'll say your bail will be considered expeditious. Don't make that statement unless you're instructed. Sorry.
Item 10.
Please, petitioner seeking for regular bail
since last 9 months he's in jail. Co-accused has been already released on a bail.
Only thing is that it's a case of POXO. Allegations
It's a
appear to be,
constitutional, it was a
it appears to be prima facie. On a bare reading doesn't appear to be,
Yes.
notice किया क्या नहीं?
नहीं, it's a fresh matter. May I request for a return?
Some date will be there,
I'm
but be ready. Notice doesn't mean that we'll allow.
on which point are you?
Victim is not a party.
She is the party, she is the party.
He's a party.
He is a party.
She is the party.
The only thing is that we will serve through the concerned essential. Be ready. You see, when we went through the story, it doesn't appear to be plausible. But if she's 14, then there's a difficulty for you.
15, but it is a, with respect to me, submit law. It is a matter of trial, her age, determination of her age.
We are
She's there about 15, but it is consensual. That is my respectful submission.
We have not dismissed it.
Yes.
We should notice, but we are telling you.
Yes, I will. Oble.
Age 88, because I am mother of your 3.5-year-old child, baby girl, my lord. And but this is a case where IPC is not made out, my lord. I am a nurse, my lord. I have got this. But this is fresh matter. The notice has not been issued, my lord.
जनाब नोटिस भी कर दिया, आपको एवेल भी दे दिया.
Our last supervisor obstetrics directed us to pay 25% of the amount of DA which to the employees.
No, sorry, which item?
Item 12.
30. Well, wait, sir.
Apologize.
Your Lordship, item number 12 I am.
Yes.
Your Lordship, the allegation against me, against the non-billable section is that I have hit the pregnant woman on her stomach. Now, this allegation does not inspire confidence.
This is a very serious allegation.
Your Lordship, this allegation does not inspire confidence, Your Lordship, because of the reason.
Why you tell us why it doesn't inspire confidence?
Because when she was in dire state, she visited a hospital.
Kindly come to page 11. Gentlemen, can anyone give a seat to Mr. Subramanian, please? Please. It's a pleasure and delight to be. Yes.
Yes, Your Lordship.
Yes.
Yes, Lordship. Page number 13 is the information.
No, gentlemen, you come to page 11. Why do you say that
Yes, Your Lordship.
ex officio it is false?
My point is, Lordship, when she was in the dire state, she visited a hospital which was 6 kilometers away from her place.
Gentlemen,
And when
the
she was
allegation against you is that you kicked her, which resulted into XYZ. We need not read the contents. It's horrible, horrendous.
Yes, Your Lord.
Thank you.
Lordship, the point is, first she went to Sadar Hospital, which was 6 kilometers away from her place. And when she was referred to RIMS,
Thank you, sir. Thank you. We are not. Thank you.
she visited the place which was nearer to her place.
Thank you, sir. Yes, please.
Application. In this matter,
He's saying they are not agreeing to pass out.
state is seeking 2 months' time. We have formed a committee.
We will request. Now we want to hear finally. Please proceed with the submission.
But as the amount is very large.
Mr. Singhvi, we are not adjourning the matter. We would want all of you to address us on merits.
Yes, sir.
Please proceed with the submissions.
So
We specially kept this matter. Mr. Singhvi, we specially kept this matter. We told you previous occasion also that we want
May I say one
to
thing?
hear the matter.
May I say one thing, Wallace? Number one, Wallace, this may not be a conducive day for a Monday hearing.
No, it is all right for us.
Number two, Wallace.
In fact, today is the most auspicious day for us.
No, not auspicious. I'm only saying conducive, Wallace, not auspicious. Number two, Number two, my lords, we need to sort out these large amounts. We want to try and find a way to comply with the Lordship's order. There are no directions in the Tribunal and the High Court. So the committee will work it out. The amount has to be worked out as per my Lord's order. The amount has to be worked out as per my Lord's order.
Of all you know, you may not have to pay a single penny. Let us submission.
Yes, sir.
Please, we are very clear. Please start.
Very well, then, my lords, we can start it. Let me start it. I'll join in then if he wants to start with.
Yeah, most certainly. Yes, Mr. Dwivedi, you start.
So, Lord, what we are submitting is this, not both the tribunal and the High Court said.
So you may no. Minutes now.
Only one sentence, my lords, I want to say before he starts. This I am saying that the High Court and the Tribunal have both not quantified the amount.
Correct.
Therefore, your Lordship's direction, even for implementation in letter or spirit, requires quantification.
Oh, what we intend to do is,
Yes.
we can see our directions have been complied with or not is not the issue now. The only thing is whether the judgment passed by the High Court is.
Very well, let Mr. Dwivedi start. Let Mr. Dwivedi start.
Yes, sir.
Hey, or if you want,
Coming up to have it tomorrow.
no, tomorrow we have already fixed it.
Next week.
Sir, 1 minute, 1 minute. Are we adjourning the matter?
No, they said tomorrow. Okay, sorry.
See, the issue is very simple. We don't, as we understand, as we read, or as we have read, very simple. What is not so what we have to examine, and we'll do it once and for all. Simple as that.
Well, that simplicity is involved in every case.
Rest assured that none would have any grievance that we have not heard.
No, that's not the point, Lords. The point is that
Therefore, we would request you to begin, please. Should you, we'll accommodate you. Perhaps we don't want you to be, caught in a surprise. We pass it over, and you come back at 12 o'clock, back at 12:30. No difference. But we want you to begin. That's it. Or you may proceed, please.
I will be as ignorant, at 12:30 as not. Let me show you. The Lordship had that next Monday.
We may, Mr. Ahmadi is here. We made it clear last time also. We are not, we'll hear it. Mr. Ahmadi, correct us if we are wrong. But I thought.
Today only the IA is listed actually. So far as the IA is
No.
that was my impression.
No problem. No difficulty.
Otherwise, your Lordship will hearing the matter finally.
No difficulty. No difficulty.
The Lordship can keep it on any news. Next week.
We'll have it tomorrow.
Yes, sir.
कल क्या लगा ना just give us some.
Okay, tomorrow.
Yes, sir.
Sir, are you here?
Yes.
You are here.
No problem. I shall.
Sir, are you here?
My lords, might Wednesday be possible?
And then we'll do one thing on a day-to-day basis. Doesn't matter. No difficulty.
Great.
No problem.
It won't take that long, Lords.
To accommodate her.
Yes, of course.
No difficulty. No difficulty.
My lords, I wrote it top of the list today. My lords could say top of the list tomorrow.
Will be so, no problem.
So,
But then all of you should be here. Mr. Singhvi will just inform. If Mr. Singhvi is not there, then.
One of us will be there. What to do?
Sir, we just want to know to set the calendar. How many of you would be arguing on this side?
Just one, Lord. No, not all of us. So one of us will be here, Lord. Others will assist.
No, that's all. No, so we want to, spread the timeline. That's what we do. Next one, two. Next one, two. And this side?
I think I won't take more than 45 minutes. 45.
No, how many would be arguing?
I'll be taking 30 minutes.
Your Lordship, Mr. Patwani.
I'll take 30 minutes, my lords. Mr. Patwali is also.
Can the court suggest one thing?
Yes, my lord.
All who are on this side, can formulate common solution.
Yes.
And one else we can divide them up, would that be helpful?
Whichever way, formulate common solutions so that we know in writing, we know what it is. So that it doesn't take much time. That's what.
We'll do that.
This side submissions we know already because this is
So they add only if your lordship agrees with us. If the lordship doesn't agree, well, then they are not required to meet its fate.
We have to hear this. It has got an India constitution. So therefore, this cannot be dismissed
Yes. Grateful.
as rate for.
Hello.
That is it.
Would you be able to make a submissions, prepare your submissions? No?
How about-
But we file written submissions, my lords, but we'll get them all together.
Confidence, please. Because we went through the written submissions, they had filed.
We have already filed this.
So we want all of you to such a composite.
No problem.
Grateful.
14.
Higher court board means they will be taken up immediately after the miscellaneous. It will be taken up immediately after the miscellaneous.
Lodge.
Yes.
They have filed the early hearing application, but even the High Court record has not yet come, my lords. The leave grant.
Final hearing in. Yes.
Just this is a matter for final.
Well, yes. Only I is there.
IAS probably.
One IA has been listed today, my lords. Earlier
We
one.
want early hearing.
Early hearing.
Early hearing. Record we called for. What is the urgency?
This is a matter related to labor minutes and the High Court order is already stayed. So because
Record
reinstatement.
record we called for. Record is there.
No, my lords, record has not yet come, my lords.
So then you have all the records.
So lords, there is a process by the registry has been issued to the.
Okay, record we called for. October and November में लगा.
Lords, one application for implement of the Guru Ghanshidas is still pending in 2022, my lords.
Allowed.
I can
Amended memo we filed.
The High Court reverses will not desperate that. If for special performance is concerned, that defendant is going to well option. The trial court will not, after appreciating the fact that there was already a sale and the fact
Only thing is reversal is not the point. Point is whether time was the sense of the contract.
the lordship looks at below page 44 for a minute.
Page 42 you come, whether after or before.
Yeah,
Page 42.
42, yeah, 42 is the agreement.
Correct.
There's been a clause there.
44.
44.
The third line, Roman 2.
That's right.
Paid after the expiry of.
3 months. So till today he has not paid.
He has deposited the amount.
No. He hasn't. But till today, these 3 months will not was paid.
See, one thing is there, sir.
Yeah.
He has paid you 4.70 lakhs.
No.
Only 3 lakh.
No, I'm sorry. Well, he paid, 2 lakh at the first instance.
Correct.
And thereafter 20,000.
20,000.
Correct.
Correct.
Yes.
As against 2.51, which was.
No, I'm sorry. 2.51 per acre.
Correct.
Per acre, it comes to more than 10 lakh rupees. And 3 lakh he was supposed to pay within 3 months. Irrespective
My lord says here is
therefore
not putting the correct fact. My lord says that here is.
And this is reversal will
We know that.
Here is my lord's.
The time of the sense of the contract.
Yes, I'll agree. But there is one problem in the executive register stated because there is the acquisition of the road. That is come in the middle of the way. He didn't disclose that. And after that, it was mentioned that after the calculation of giving up the road part and what would be the amount, it must be calculated. And in between, my lord, there is a suit is filed by the insisted of it against me. That he said that there is a stay order from the OAS. That is, can I read out that part, my lords?
Notice.
stay.
Status quo as on date. Status quo. Operation of the judgment also.
My lord. The suit for partition was filed, my lord, in the year 2009, while I was all along in possession since 1989 by virtue of a family settlement.
No, that family settlement, unfortunately, you have not been able to neither place prove nor.
Lordships are right, my lord. Today, what I am seeking, my lordships, my lord, it's a 50 square yard house, my lord. It can't be divided by meets and bounds, and one property is also having. What I am submitting, my lord. Let us sit here. Once notice is there, he'll come. We'll pay, my lord. But if there is some valuation, my lord, that's the only solution.
Court can do.
My lord, we tried, my lord, but he's not coming forward, my lord. We tried. He's a retired doctor, my lord, now at this age, my lord.
No,
where did you So, my lord,
where did you try?
Shimla, my lord. We tried all through the Buddhism, my lord. He's so adamant, said no. That's very difficult.
Execution will be done now.
Execution also, my lord, he's just putting his knife.
Sir, one thing.
My lord.
In the execution, the executing court will balance the equities.
Lordship may just indicate, my lord, that. Lordship may indicate at least that, my lord.
But I'm such
Indicate that at least in my lord, in execution, mediation will be tried. Just one line, it will help, my lord. I'm telling you, my lord, I'm trying, my lord.
So we are not inclined to interfere with the impugnment. But we find no reason to do so. At this stage, then counsel submits that petitioner is ready and willing to sort out the matter amicably with the respondents. And counsel to the petitioner submits. Well, all this can be tried during the stage of execution.
Deeply obliged.
17.
Very well authored judgment.
You know, 17, in the beginning, I must. That there is a delay. I'll explain the delay. Now, the only point, my lord, here is, they are the fag end of their career, 2-3 years to retire. I only want the pay scale, same pay scale as the other diploma engineers are getting.
Cannot be, sir.
Same, even kindly just sub-assistant engineers are also diploma holders. They are getting scale 10, they are getting scale 12, we are getting scale 10. Kindly consider, Millard, scale, we are getting scale 10.
We only wish, we are immediately we do it.
Millard, I am requesting because these are only few people. They are only few people.
By no stretch of imagination, even if your case was 0.1%, we would have immediately issued.
Well, I'm only requesting, Millard, since they have 2 years of service left, it's only a question of scale, Millard.
But then you're not entitled to eligibility and entitlement is the issue.
No, Millard, we are diploma holders, and some of us have been designated as sub-assistant engineers. They are also diploma holders.
Oh, it doesn't take a minute to issue.
Millard, all that I'm saying is, they are from land and land forms department.
Not possible.
In that event, I would request your lordship to kindly condone with me.
Yes. Yes, ma'am.
My lords, this is a matter where the employee she's worked for 10 years and is seeking for regularization. My lords, as per this honorable court's judgment, the regularization can only be for a duly sanctioned post. However, at the time when the employee had joined the services, he was not employed against a duly sanctioned post, my lords. If my lords may have, he was engaged as a cleaner, my lords, in 1987. Thereafter, his services were discontinued and he was terminated as his probation period came to an end. Labour Court had directed the state to reinstate him. He was duly reinstated by the state in 95. Thereafter, my lords, he's been continuing working. However, the respondent is demanding for a regularization of his employment.
What is the date of the award?
My lords, the date of the award is 23/5/1997.
Working since then, why do you want to dislocate him?
My lords, it's just regularization, my lords. As per this court's judgment itself, my lords, may have KUMAR as well, my lords. It clearly states that while directing the appointments temporary or casual be regularized or made permanent, the courts are swayed by the fact that the person concerned has worked for some time and in some cases a considerable length of time. It is not that as if the person who accepts an engagement either temporary or casual in nature.
What's your good name?
Mr.
Stogi is now we are impressed with the submissions made by Ms. Stogi. However, despite the same, we are unable to pursue ourselves. Thank you.
Item 19.
Yes, please. 19 password.
My lord, I am appearing for item 19, my lord. My senior will be appearing in this matter. Lordship may kindly pass over this matter.
Okay. Okay, you are good enough. You are senior for us. Why don't you argue? Juniors are getting opportunity in this court.
My lord, my senior insisted to take a pass over in this matter.
Tell your senior that we insist that you will argue.
My lord.
Are you ready? Argue.
My lord, though I am very prepared with this matter.
Argue, please proceed.
My lord, if your lordship may look upon paragraph 8 of the impugned judgment, my lord.
Yes.
In this, my lord, in this paragraph 8, the Honorable Guwahati have itself observed the fact the present case pertains to there has been a short delivery of the consignment by the railway claims by the railways, my lord. And if your lordship may look upon paragraph 8, the Honorable Guwahati.
Just 1 minute. What's your good name?
Divyansh Rathi, my lord.
Mr. Rathi, you do one thing. Just take down. Note down.
My lord.
Just note down. The risk policy is not on record. Everything turns on the policy.
My lord.
See, section 97 will come into play only when we see where is the policy. Number 2, you have not filed your reply to the, you have not placed on record the written statement. Just to take down. 3, you have not placed on record your legal notice and the reply, if any, to that legal notice. Just take down.
My lord. 106 notice is there.
So where is that page? I couldn't see that.
My lord, 106, section 106 notice is at.
Anyhow, if it is there, it is there. Doesn't matter. But
this policy.
This policy is not there. So place it on record. Okay, what is your good name?
Divyansh Rathi, my lord.
Okay. You argue a little bit more.
My lord, if you look upon, lordship may look upon paragraph 8, my lord, the Honorable High Court has itself observed that there is a short delivery of the consignment. And just because it was booked on the owner's list, my claim was repudiated, my lord.
No, that is not the point. We appreciate that you argued, but that's not really the point. The point is section 97, this policy. That's it. Shortfall is not the point. Anyhow, Shri what's your good name? Shirati. You heard Shri Divyansh Shirati. Yes, sir. And Council undertakes to place on record documents by way of a the deed should be done within 1 week. And then just see whether any reply was there to the legal notice or not. And you place on record the legal notice again and also the WS.
I'll put that, my lord. I'll put that.
In notice returnable steps.
Much obliged, my lord. Deeply obliged.
Good, good.
That we allow. What is the point in the money lying there and it's
you do one thing, you furnish a bank guarantee and take it.
The order was, the earlier order was.
We have seen that it has modified. Now it's 100% money amount is not small.
The bank guarantee would be again putting the money in the bank only. I am not going to what's it?
How does court wants to secure the money?
The order of the first occasion was.
See that
50% and 50% on security. I can withdraw it only on security.
Security.
So means I can give the involved property as a thing, but this is my money. It is admitted fact. This is my money. This money has been given by me, and no goods have been supplied. So the bank guarantee would be, please I'll take inspection. Yes.
List on his request.
Give me 1 week. I'll take it.
You want password?
No, also give me 1 week. Please I'll take inspection and come back.
Item 21.
Lords, in item 21, Lords, I am led by Mr. Diwan. I am seeking.
It is to be checked.
Yes, my lord, it is to be checked.
Checked. We will order to. We are.
Item 22.
May I please, Your Lordship? Lord, this is a matter where Your Lordship has since for the same year, in fact, my Lord. The
only thing is, ma'am, that waiting list will not survive for the simple reason. We'll tell you 2-3 dates. Then you answer.
Yes.
See, the notification in this notification dealing with you was on 29th of March 2017. Correct? And prior to that, prior to the expiry period, fresh notification was issued on 6th of August, 6th of June 2018.
Yes.
So how do you?
Lord, the 6th of August notification has nothing to do with the period that I am concerned with.
Because the rules say
no, my Lord,
it's
the provisional allotment. Because
validity of the list is for 1 year or till such time the notification is issued.
Provisional allotment. Lord, I'll show to Your Lordship. That is, my Lord, the 3 dates are vital, and I'll tell how High Court has gone against me. Para 2020 page.
Forget how the High Court has gone against you. You please tell us.
I will.
Can we come to page 60?
Yes.
Can we come to page 60?
60, my Lord?
That's right.
Yes.
Roman 3.
Yes.
Page 60. This is concerning you.
Yes, Lord. This is my letter which has been sent to me by the bank.
1 minute.
Yes.
You are Kunal, na?
Yes, my Lord.
This is to
I'm
you.
the only person surviving, my Lord.
1 minute. This is to you.
Yes, my Lord.
Now read Roman 3.
Yes.
Sorry, not Roman 3, but 3.
Yes, my Lord. The reserve list will expire automatically on the day which is 1 year after the date of provisional allotment. That is 31st January 2019.
Read further.
Yes, my Lord. Until a fresh provisional allotment.
Or until
a fresh allotment.
A fresh provisional allotment is made, whichever is earlier.
Yes.
With or without any notice.
Therefore, my Lord, Your Lordship is right. Your Lordship is looking at me. I just showed to that para.
And prior thereto, the fresh advertisement was issued on 6th of June 2018.
So, my Lord,
and allotment was made.
Yes. So the date which is germane is, my Lord, is not the date of advertisement but the provisional allotment.
And we are saying that prior to your filing of the writ petition, allotment was made. This is what we are saying.
So therefore, I know I'm coming to that, my Lord, and Your Lordship will see. My Lord, may I just?
And my Lord was just reminding me that you filed the petition much after the allotment had been made.
The validity
Lord,
of the list was over.
Yes.
So,
Lord, may I just show one page from their reply, page 94.
Reply, we don't have to see.
Yes, only because, my lord, what is the illegality and how single judge has dealt, my lord? Because for High Court there has to be some perversity in the order of the single judge to say, my lord, may I just only one second. My lord, yes.
it is
My lord,
contrary
because
settle law.
because on
It
20,
is perversity.
my lord, the reason why I want to show to your lordship. Yes. My lord, your lordship has page 94 and I want to show these documents in conjunction with 94. My lord, page 94. We could not the typed copy. Your lordship will see this is with respect to, my lord, only I read the 94 page from the paper book. And this is that document, my lord. 94 is a part of annexure P8, my lord. This was an additional statement which the authority IIPP filed pursuant to the direction issued by the single judge that what have you done with respect to the vacancies which remained unfilled. Now, my lord, page 94 is the stand taken by bank saying it is submitted that since there was no vacancy reported by the respondent, the fifth respondent has not allotted any candidate from reserve list. The regarding provisional allotment of the candidates from the reserve list drawn on 26/12. So on 26/12, they draw a list and your lordship has those three lists and it shows 0. And therefore, my lord, the question arose before single judge that whether the bank has acted illegally, which is at page 118, my lord.
We are only again putting it to you that you file a writ on 29th of January 2019. Prior to that day, not only the subsequent selection process was over, but also allotment made.
Yes. My lord, that issue will, my lord, in my humble submission, my lord, your lordship will only see one point because this aspect was dealt. My lord, I cannot deal it better. My lord, your lordship will only page 118. My lord, your lordship, I will not.
Certainly.
Page 118.
How do you answer? You are not answering.
Single judge has answered, my lord. So my best defense is the single judge's order, my lord. Because page 118, your lordship has because learned single judge formulates two issues. Page 1.
We have seen that.
Yes, my lord. And therefore, if the bank has acted illegally, my lord, if there was a reserve list, there was a vacancy, they had to operate the reserve list, my lord. If they do not, because your lordship will see on 26/12, they say that we have no vacancy. And after the examination of affidavit RTI, court comes to a conclusion that there were vacancies and reserve list ought to have been operated.
And the point is very simple. The validity at page 60 we told you is for a particular duration or a particular eventuality. Then that eventuality took place, the list lapsed, and therefore you have no right.
For that purpose, may I just show because there is one, Lord, at page 172.
Thank you, ma'am.
Lord, 172, your lordship will see because what is the illegality which they have committed. Lord, only 172, my lord. Your lordship will see it for my satisfaction. 172, if I may. Yes. Yes, 172, my lord. My lord, this is the RTI reply because Lord, the learning division bench was on under impression from what yes. My lord, what we filed was we filed an RTI to see that how many seats vacant for RRB PO 6 to 10. 6 to 10, my lord, and my lord, your reply will see for each year that these were the vacancies. And at the bottom, my lord, your lordship will see the last 4 lines. RRB 6 not recruited from reserve list. RRB 7 not recruited from reserve.
Did you not bring it to the notice?
Yes, my lord, I did. Because yes, my lord, because only one, my lord, one seat today, my lord. My lord, only one seat, my lord. Only, my lord, your lord, for the limited purpose.
I suggest you one.
My lord.
File a review. Seeks permission to withdraw the present petition. Reserving liberty to file a review.
With respect to your lordship, will mention the RTI.
1 minute.
Answer.
More so, in view of the document dated 9/5/2022. Investigated for 3 months. So, liberty to approach the court again should be.
Deeply obliged. 23.
I'm agreed by fixing of a fair rent. Worship, the agreement was dated 2011.
725 square feet. Where that area?
Yes, Lordship.
725 square feet of area,
Yes,
the
Lord.
heart of the town,
Yes, Lordship.
and only 35,000.
May I just
30 rupees per square feet.
may I do just one
You
thing?
do one thing.
Yes, Lord.
We'll call the gentleman here. We'll waive off your rent, all areas, and you hand over possession.
Lordship, may I say just one thing and I'll leave that. 2011, he was paying 8,000 rupees. And the fair rent, which was fixed for 15,
From
in
8,000, it has been enhanced to 21,500 and then further by 35,000.
34,000.
We are saying
Yes,
from 8,000 to 21,000 and then to 35,000.
35,000.
So we are 725 square feet of.
Which I was supposed, Lordship, there is an increase of 400%.
We are giving you another offer,
in
counter offer.
Let notice be issued.
On.
So I am here for the petition.
Sorry?
I am here for the petition also.
Yes, please.
Let's say I am the assistant professor in Banaras Hindu University.
Yes, yes.
Let's say I am discriminating since 2020 also. That's it, can
Yes, argue.
That's it, the university received notification for assistant professor, professor and associate professor also.
You participated in 2024 also thereafter and failed again.
Lordship in 2024 without conducting.
No, gentlemen, one thing. In 21 you participated.
Please, Your Lordship.
Correct?
Please, Your
From 21 till 24 you kept quiet.
Lordship.
1 minute. And in 24 again you participated, as my lord has put it. Now you say that no, 21 was incorrect.
Lordship, I filed the objection on 28/10/2020 that the single respondent did not take the interview. He stated that the single eligible candidate, OBC single eligible candidate.
Yes, you are arguing very well. Continue. Please continue.
The post under OBC category not to be conducted for the single eligible candidate as per the BHU ordinance. Can you see the BHU ordinance, page number 13H, Your Lordship.
We've heard you.
Let's
You argued very well.
Let's see the page number.
You have not answered our query.
Please.
See, we were only trying to encourage you to open up. A 2021 process is there.
Please.
You participated. No challenge to that.
Please.
2024 process was there. You participated. Only because you were not successful in 24. Now in 25 you say 24 was bad, 21 was bad.
Lordship, in 24, the interview not conducted, Lordship. Without conducting interview, Lordship, declare NHS, Lordship.
Thank you.
Item 25.
Please, my lords. Foundational and fundamental perversity is the order of the matter, holding that the respondent number 4 is not a government company. And my lord, evidence of record totally and completely established.
Deep and pervasive control, that's the test. Only
Yes.
because of officers are there on the committee,
Right, it was,
that cannot, 1 minute,
yeah,
gentlemen.
your lords.
Only because officers are there on the committee, can that be a test to determine whether it is a state or not?
Yes.
Number one. Number two, you want absorption in the government employee, as a government employee. That can't be done.
Lord, your lordship,
In any case, deep and pervasive.
I have specially come from Goa, Lord, your lordship, you can give it to me.
No, certainly, we are not. Sir, please, don't be under this
Lord,
impression
your
that we
lordship
are.
will see. My lords are aware. Lord.
One minute. What's your good name, sir?
Surendra Desai.
Mr. Desai. We will spend the whole day here listening to you. No difficulty. But you have not you have to answer our query.
Yes.
Only it is a society. Some of the officers of the government are members of the office bearers of that society. Now, would that alone itself make it a state?
No.
What we are asking.
There are so many more factors.
Correct. Now we have
yes.
Yes.
Your lordship will see, your lordships are aware that UNO falls under item number 12 of the union list, is a central government activity sequence and subject of the central government. Now, my lord,
UNO.
United Nations Organization.
Yes.
It is, my lord, falls under item number 12 of the union list.
Constitution. Some simple thing, huh? Oh, yes.
My lord, have it. Item 12, Schedule 7.
My lord was asking that what has got this entry and United Nations got to do with the adoption of the... One minute. So I told my lord that we'll have to listen to you, that what is it that UNO has got
deeply grateful
to do with the absorption of the government employee.
I don't think Uma Devi has authorized UNO to frame a scheme for absorption or regularization.
But India is a member country of UNO.
But that issue was not raised before Uma Devi, which is a constitutional mention.
No, but then, my lord, UNO contemplated a scheme for its member country India. Entry 12.
But that should be raised before Parliament.
Yes, my lord.
That should be raised before Parliament. The government should frame a law by honoring, respecting the UN resolution.
But kindly, my lord, this program was UNO-sponsored program for the member state India. India accepted the program, and as a beginning, Lord, subscribed to this program for a while. Thereafter, Lord, Government of India funded this program, and thereafter, Government of India transferred it to the Government of Goa, the responsibility of funding this program.
Can we request you for one thing, sir?
Yes, my lord.
From page 54 onwards, 54 is your certificate of registration, number 1.
Yes.
Page 58 is your memorandum of association. Now,
yes.
It is conspicuously silent with regard to any activity that of the UNO.
This is the UNO-sponsored program.
We do not know.
It has been mentioned in the pleadings.
UNO is not funding absorption.
Lord, it is a UNO-sponsored program. My lord, may kindly turn to paragraph 5 of the affidavit filed by the government.
Now, Trump may not allow UNO to do that.
That your lordship will see.
It
is a UNO Sorry.
No, what we are asking you is.
Yes, my lord.
See, UNO, that it is an UNO funded or project under the aegis of UNO is nowhere mentioned in your memorandum of association articles.
No, it is not mentioned, may not be. But your lordship will see how it is necessary to find out
how this point has been dealt with before the.
Lord, that has come, my lord. Your lordship will see the improved judgment about the. Kindly, my lord, turn to paragraph 13. Paragraph 13, my lord, finds.
No, that is your argument.
Yes.
How this has been answered?
It has not been answered.
Then you should
And
file
it
a
will be
review.
answered cunningly to say,
Cunningly, don't use that.
I'm sorry.
No, please.
I'm sorry. Whole idea was to throw us out. And we are fighting for several years.
We don't want you to say that when we.
But diving into para 18 of the improved judgment. I'm sorry, my lord. Page 17, para 18, my lord, of the improved judgment. Lord, there is an admission at paragraph 18. I will not bother you, waste your lordship's time.
Your best argument is that Honorable the Chief Minister at one point of time had made some assurance to you.
Yes.
Not in the floor of the House, but in the files of the Secretariat. That's
That's
your best argument.
We were all government servants. And what was our request? Our request that, all right, you have closed this TRTs. Enlist us in government employment.
Mr. Desai.
And then the yes, I'm sorry.
My Lord has given a route way out. You file a review petition there.
Lord, review petition, it is too late now, Lord. Kindly turn, Lord, for a second, Lord, bear with me. For a second, Lord, bear. If your Lordship may kindly turn to paragraph 18.
Yes, sir.
This is the admission on the part of the government. Mr. Deep Shirodkar, my Lord, at page 17, paragraph 18 of the infusion.
Yes.
Mr. Deep Shirodkar, the learned additional government advocate, on the contrary, would rely upon the affidavit filed by the Undersecretary Personnel, Department of Personnel, Government of Goa, filed on 27/6/23, and he does not dispute the fact that PRTC was originally constituted to be an institute to be financed under the United Nations Development Program, and it was to run from funds received under UNDP. After the said funds were exhausted, the affidavit states that the memorandum of understanding was signed between TRTC and the government, which was supposed
How
to.
does it help you to say that it is a state?
Your Lordship will see the sequence as it has come out, my Lord, on record.
We have gone through the files, sir.
Yes, Lord.
We have read the judgment and we do not.
Lord, judgment doesn't tell the things correctly, not in sequence. I'm sorry.
Thank you very much, sir.
Lord, I'll be out. I have been fighting for this employee, they are fighting for years. And what we are saying,
we have heard you enough.
Even today, Lord, if I am absorbed in the surplus pool, I will get employment. Lord, it is a reasonable thing. We are thrown out by the government.
You were Mr. Desai, you were the employees of the society. That society has got nothing to do with the activity of the government. It is a UN-aided project, or maybe at times government may have given some money to you, and you have been carrying out the activity as was required by the UN, and that's about all. You are not a government employee. You cannot be absorbed as a government employee.
I am trying to point out for your Lordship's consideration that I am a government employee. Please allow me to establish it. I am a government employee.
We have heard you now, sir.
Thank you, Your Lordship. And it's the final report. I will comment.
You tell us. You see, we are conscious of this fact that we are the final court.
Yes.
And two things always bear with us. There shouldn't be travesty of justice.
That's right.
We must do broad substantial justice.
That's right.
These two things always weigh with us. Now, we are telling you by what?
Look at the thing, what is happening.
What state of imagination can we bring you to be we bring you to the government fold? You tell us this.
Your Lordships permit me to explain, Lord. I think I will.
Okay, do one thing. Absolutely.
The government servant.
But your Lordship will see, this was.
Principle. You are not recruited. The only way is either regularization or a third one.
By following the procedure applicable to government servants. All the persons.
Therefore, you become the government servant. No. Even if it is not, we have a recruitment drive.
All the personnel who were managing this society were acting government officers holding class 1 position. Now,
nothing, Mr. Desai. Sorry, dismiss.
Item 26.
Issues involved with the case, my lord, whether the trial court, while passing the award, passing the maintenance, my lord, that the date which shall be considered is the date from filing the application, my lord, or the prior date. What happened in this case, my lord, the trial court had awarded the maintenance and that the considered the date, that is the 2016, year 2026. While, my lord, the petitioner has filed application in 2019.
From 16 to 19, what will happen?
Yes.
So child and my wife are not to be maintained.
It was maintained, even my lord, I was maintaining,
You are in Dubai, so
no,
4 lakh rupees salary.
not at all, my lord, even 12, already, my lord, 12 lakh has been paid.
Your child.
My lord, I am ready to pay. My lord, only 2 submission is, my lord, in this case. Kindly consider, there is a judgment, my lord, to settle all this anomaly, Neha Rajesh and recently, my lord, Shahjahan. Supreme Court, my lord, observed that there is, my lord, the issues in all the previous cases. What is the exact date we shall be considered? Sometimes what happened, my lord, lady separated from the husband 2009 and 10. She filed a maintenance, my lord, after 10 years or 12 years. And they claim, my lord, that the maintenance way back, my lord, sometime 2010-19. Same happened in this case, my lord, where the wife claimed maintenance prior to filing the date of obligation. And my lord, kindly see that.
No, here it is not granted from the date prior to the date of application.
Prior, my lord.
Where is that?
Yes. Kindly see, my lord, the.
Where is that part of the order?
Yes. Operative part of order, my lord, paid case number.
So this is
159, my lord.
That will be determined. You argue it before the court.
No, my lord, that.
This is an interim order only, directing you to deposit 40%.
No, this is not interim order, my lord. Interim order, I have been fast. I have deposited 12 lakh rupees. Even today, I am ready to deposit, my lord. What is the difference?
Don't argue contrary to records.
No.
Why do you say it is not an interim order? Read the order.
My lord, 150.
First, you must understand what is an interim order and what is a final order. Read it.
My lord,
it is only 8 lines. Read the entire order.
Kindly see, my lord, the operative part.
You read from beginning.
Yes.
Only 8 lines.
Yes, my lord. The present petition has been filed by the petitioner's son through his mother under Section 20 Hindu Adoption and Maintenance Act. Yet by Section 7 Family Court Act, seeking maintenance from the respondent.
No, page 3.
What are you reading?
We are reading the High Court order.
Yes. Yes.
Gentlemen.
I understand, my lord. High Court has simply, my lord, that.
No, please understand.
Yes.
Dismissed.
My lord, kindly.
No. You are not arguing what we are.
My lord, I understand.
No, we will not hear you. Dismissed.
My lord,
Call the next case.
My lord, just.
No.
Apology for my lord. I am just.
No.
Trying to one submission. Last
Thank
submission.
you, Jen. We'll tell you.
Interim order.
We'll tell you.
Yes.
The High Court order, is it not interim in nature?
Interim nature, my lord.
Why did you say it is not
Yes.
interim?
No, my lord, I am just sorry, my lord.
That means you have not understood the case.
My lord, I am.
You have not prepared the case.
I am a prepared.
Suffer the consequences.
Now 1 minute, my lord. Just 1 minute.
No, matter is over.
My lord, 1
Thank
minute.
you.
What is the difficulty?
Thank you.
My lord, 1 minute, please. I am ready to deposit the amount, whatever my lord fixed.
You will not argue now on minutes. If you want to say anything else, you can say that.
My lord,
We have to.
yes,
We are
yes.
here. You are a smiling face.
My
What a
lord.
lovely face you have.
My lord, I just.
You have.
I go down, my lord. I understand.
Now,
I
matter is over. Then.
Yes, yes.
Matter is over. It's an interim order. Go back to the High Court. Tell whatever you have to tell. Yeah, please proceed.
And never argue contrary to facts.
My lord, I just.
Never ever argue contrary to
I am
facts.
talking about the trial court order that is final nature, my lord. Sorry for that.
Trial court order is part of the. It has been said before the High Court or no?
But my lord, the order has been passed against the settled proposition law.
Thank you. Next.
This is the whole issue. That cannot pass, my lord, before the date of filing application.
Thank you.
The petitioner is a permanent employee, my lord, Item 77 of Bombay, the Brihan Mumbai Municipal Corporation. So the rule 8 is, my lord, very clear that there should be departmental inquiry. I was absent for certain time because I was
especially considered tribunal for that.
But my lord, there should be departmental inquiry as per the rule.
Will you go to the High Court straight away or will you go to the tribunal?
My lord, I went to the High Court and at least there should be some departmental inquiry and they are sending me to tribunal, my lord. Rule 8 is clear. Before
the whole difficulty is if this is allowed, then every workman would approach the High Court.
My lord,
And what for the labor court or the judicial court would be
Page
constituted?
number 39, my lord, they terminate.
And this will be setting the wrong precedent.
But before termination,
I don't think we flooded with cases of these.
opportunity needs to be given as per the rules, my lord. Rule 8 is very clear that I should be given an opportunity. Obliged. The delay may be condoned, my lord. Delay is condoned. Obliged.
Please, Your Lordship. Lord's 2019 accident, my lord, the
Your smile is all telling. Thank you.
So, Lord, may I say one? 3 crore award, my lord, income which was there in 2014-15 has been realized. My lord, the court itself says that there is no evidence and we are relying upon this income of 5 years back income, my lord. My lord, delay may be condoned.
Lordship, for 60,000, Your Lordship, the corporation petitioner has no problem, Your Lordship. But to pay for 14 years, Your Lordship, because we have paid earlier, Your Lordship.
Filed by the employer, by the employee.
No.
We are asking any appeal filed by the employer.
No.
Employee.
No.
No appeal.
Only corporation.
Employee
And we have from 97 to 2010 we have paid.
Yeah, I should. Okay.
Like a stay, otherwise they have said that you must stay.
Only thing is
subject to some
deposit.
Some deposit.
50%.
I'll deposit the whole 60,000.
You deposit the entire amount.
Yes, sir.
Subject to deposit of the entire.
No, Lordship, kindly 60,000.
50%.
No,
50% the amount.
No, Lordship, it is a 9 lakh, Lordship, then it is very heavy. That is why I have come here.
50% we are saying subject to deposit of 50%.
Then it will be.
Kumar Sarkar hai. Himachal Sarkar itni bank
No, there's no money.
Kumar 50% deposit.
Lordship, allow me to deposit 60,000. I will deposit within 1 week.
50% deposit here.
Please. Please.
Please, Lordship. Lordships, in this case, Lord, the division bench, Lord, without there being any challenge to the rule, Lord, now they have said that the main rule which says that the date of joining and confirmation, that will be the relevant criteria for assigning seniority. Lord, now they have decided that the selection committee which makes selection and the appointing authority which appoints the person subsequently, Lord, they say the merit has to be maintained by the selection committee, not by the appointing authority. And Lord, all these petitioners, they were not party, nobody who had made party. Now, Lord, all lists have been revised. And Lord, now these people who have been promoted, these appellants.
No, you were lowest or you were in the top of the list?
No, Lord, we were, as per our appointment, we were obviously higher than those people who went to the writ court. And Lord, they did not challenge those seniority as well. They said that implement this order.
You were not parties before the High Court?
No, my lord. We were not made parties, my lord. We have sought permission from this court. And my lord, only 2 were there. And without even issuing notice, the division bench has can't see the rule.
Just come to page 11.
Lord.
Just come to page 11.
Lord.
That is the rule.
Yes, my lord. My lord, seniority in the lowest grade or category of the service shall be determined by the date of confirmation. And other higher posts filled by promotion shall be determined from the date of confirmation.
1 minute. You are the lowest grade or the highest post?
My lord, we are lowest grade.
Lowest grade. Then, sorry.
No, my lord, we are lower division of class, my lord.
Just read it, please. Seniority list in the lowest grade or category of the service shall be determined by the date of confirmation.
This is what we got, my lord. As per confirmation.
You confirmed.
My lord, as per date of confirmation.
You confirmed.
My lord, we were confirmed, my lord, in 2015. 15, my lord, we were confirmed in 2015. Lord, she just give me 1 minute.
Who says only in accordance with rules?
Lord, this is what I am saying, my lord. That 2013 we were appointed, 2015 we were confirmed. Those people who came to writ court, my lord, they are appointed, my lord, subsequently to us. And now they are saying that assign a seniority as per the merit which was assigned by the selection committee. And selection committee, my lord, prepared a list, sent to a different panchayat samiti.
You can go back to the High Court and file a...
Lord, but this now they are reverting us, my lord. This is what we are saying. My lord,
go back to the High Court and file a... Let the High Court decide because we don't find any information.
But maybe I am not able to make it clear.
We are very clear. We have read the rule. And we
That's what I am saying, my lord. That's what I am saying, my lord. That, my lord, the rule says.
You take your chance.
Gotcha.
Since you were not a party before the High Court.
Gotcha.
You go and file a
My lord, 2 of them were there, I have said. 2 of the appellants were there. And rest of them were not there. My lord, I am just saying
that rule.
You want to file a review, that's it.
No, then Lordship permit me to file. a review.
Seeks permission to withdraw the judgment. Get at the proceeding in accordance with law.
Item 31.
It's my senior counsel.
Please, my lords.
Yes.
Lordships, in this case, there is material concealment, lordships.
You're accepting?
But I have one point to make. It has been made right, is that there is a concurrent finding, my lord.
We know, we have seen that. Are you appearing for number 1?
Yes, ma'am.
Such notice.
There is a contempt which is pending.
Notice, stay.
I'm grateful.
Grateful, lordships.
Reply 4 weeks to join the court.
Please, Your
Most
Lordship.
grateful.
Yes, please, Mr. Desai.
Because Your Lordship were good enough to grant a review to me. Your Lordship may mention
No, you want to, we have dismissed it. You want a review?
a review, Your Lordship wanted to send me back to the High Court.
No, we didn't want to send you back. Sorry.
No, that Your Lordship said it, I am very.
No,
We file a review, my lord.
No, not in your matters. In other matters, we are saying that go and file review, not to you.
This matter also Your Lordship has said. This is 25, item 25.
Order recall seeks permission to withdraw the permission preserving liberty to file, seek review of the.
Oblige, my lords.
We'll just be back in 5 minutes.
Item 30.
In this case, there are two separate incidents.
Not this. They should.
Item 33.
The SLP is against the acquittal. The only sin I have done, my lord, I tried to help my colleague and given some money.
They should.
Item 34.
Yeah, please, your lordships. So it's only completed.
Just 1 minute. Yeah, not before.
Okay.
Not before a bench of which.
Item 35.
Yes, sir. Lordship, in this case, Lordship, the Honorable High Court records a finding that there was a motive on my part.
No direct appeals. Notice.
Item 36.
Hey, please, Lord. These are two matters, my lord. In fact, 36.1 is the matter, my lord, where the first.
But we got to Chandigarh, that's about all. How far is it?
My lord, with respect, my lord, only two reasons, my lord. Bathinda has a natural jurisdiction. Parties got married there. My lord, will just bear with.
One matter is already gone to Chandigarh.
With respect, my lord, with respect. So, my lord, parties got married there. My lord, will just bear with me. They resided there. Chandigarh has no natural jurisdiction. He is on a transferable job.
Bear with me, bear with me. We are duty bound to listen to you.
My lord, will just give me a minute, my lord. I feel I have a case here, my lord. Just give me a minute, my lord. My lord, what happens is the wife is residing at Bathinda. Now he is at a transferable job. So Chandigarh or Bathinda will definitely do not matter. Now there are 3 proceedings which are already going on in Bathinda, out of which, my lord, 2 have been transferred. And please look at the reasoning, my lord, employed by the High Court. They say that he is in a transferable job. And I am a well-educated lady. 250 kilometers, how will it matter? Now, my lord, I am residing there. The convenience is also there. My lord, the convenience, all the evidence, everything is there. Jurisdiction.
Defense person.
My lord, as my lord.
Item 37.
My lord, 2 submissions for your lordship kind consideration, my lord, of this matter.
Mediation is a way.
Lord, mediation, my lord, fructify, we had given certain suggestions. My lord, either developer, we had also thought that we are there for now almost half a century, so instructed and we get that.
Mediation is failed.
Yes.
Yes.
Now, my lord, I have 2 submissions for your lordship kind consideration.
You are the tenant.
I'm the tenant. Just give me 2 minutes, my lord.
Yes.
The respondent is a builder my lord, a developer who bought this property for development. He sold one of the part of this property. He sold it to somebody else after purchase.
I didn't
I'm sorry.
I did mediation claim.
Lord, mediation, my learned friend was there. He put it wrong.
No, is the gap?
No, it's not. We offered to buy the property.
No.
No, it's not about money. They say that they don't want to sell it. So we tried to convince them for that, and it didn't.
We said, my lord, he developed it. This portion we can buy it back because he's the developer. He has already sold a part of it. It's the company.
Well, the mediation lordship, they need this for their personal business, and that's the reason why they were not willing to sell.
You're a developer, and if you are into the market for
this brother is not a developer. That's a wrong position being taken. If this brother runs the company, which is the respondent before members,
so
they are not a developer.
1 minute. No problem. We'll sort it out.
Very
sort it out. Mr. This one. He will give an undertaking to this court that he will never ever sell this property. Number 1. Number 2, you buy him out. Simple.
Yes.
No, but Mills,
we appreciate what you're saying.
Yes,
we want to strengthen your hands.
Yes, Mills.
That you are a builder. See, we know that he's a tenant.
Yes.
He's a tenant.
Yes,
Mills. We know that he has lost.
Yes.
We can dismiss it outrightly on no difficulty. See, so that's the end of the matter. We only thought that there was something in the matter for you to reconcile.
Absolutely.
If you're genuinely, what you're saying is genuine, it's issue that you want it for a bona fide need. No difficulty, even undertaking with this court. Because they say you're a developer, No problem.
given under him that we're not going to sell the property. Yes, well, that he wants to run his own business.
And that we obviously then you'll have to buy him out.
Well, the business that he is running is a jewelry
It's a
business.
need to defend.
I no, well, this is the eviction, well, it's the High Court.
No problem. Admit.
Well, may I just place one small thing on it? I bow down, just one small thing.
It's a need to defend matter, madam, not try.
Well, may I just place one small thing? I bow down, and I Lordship is admitting I bow down, Lordship. I just have a small request to make. Well, the ground.
Never play with the court. That's
I bow down, well, I have no
simple.
Well,
Play with the court.
I have no difficulty with it because I am only on one small legal issue which had been argued on the last day, which was with regard to the fact that I am a body corporate, so therefore whether we have right under 14(1)(e), and that issue was pending before the Honorable Delhi High Court. That is the ground on which Lordship had said that we will settle to mediation. Well, that matter has been decided by the Honorable High Court. Division bench.
Never play with the court.
If Lordship pleases, Malak, may pass over, I can come back. He's here in court, so I can ask him if Lordship wants an
We'll never come in the way of happiness of the society.
I bow down, Malak, I fully get what I understand what's falling from Malak.
Never play with the court.
Malak, may I just then come
back? You may have the worst of the case. You may have an excellent case, but never play with the court.
No, Malak, that's not my intention at all. My only point is, Lordship, then I will ask him. He's standing right here. So I can just ask him, Lordship may pass over, whatever, and if something is to be done, then I have no difficulty, Malak. We never said no, we participated in that.
Mr. Maninder, we both.
I have no problem. I'm not trying to sit down with
one. You might have a coffee, have together, and then sort out.
I'll do it. I'll do it the way your Lordship court is observing. We'll do it.
We'll do it. I have put an end to this litigation.
Yeah, I'm
No,
not.
that's okay. I bow down, Malak. I have no difficulty with that at all.
Next week.
Go.
Please, we are again emphatically saying, sort it out.
I bow down.
Any which.
I bow down. I bow down.
No, leave granted. We are recalling that order of leave granted.
Yes, no difficult.
We are just fixing a date in the matter, Lordship.
Next week.
Very.
Monday. Coming Monday.
Yes, I bow down.
Item 38, apart from the fact that I must admit that there is a delay that is.
Delay is unknown.
Already. Just kindly consider one thing, Millard. These are 4 superannuated Group D employees. Now, Millard, they had put in 10 years, 11 years, 12 years, followed by 7 years. As now they have fallen short by somebody.
3-4 years.
Somebody
2 to 4 years.
Somebody maybe 3 years, somebody maybe 4 years.
2 to 4 years, High Court.
2 to 4 years, correct. So, my only respectful submission is, Millard, there are 2 rules, Millard, Rule 36 and Rule 4 of the Death Cum Retirement Benefit, Rules 1971. So, Millard, there is another case which was decided similar by the Calcutta High Court. Matter came here at the instance of State of West Bengal, page 43, you know, if you kindly see, that was dismissed.
High Court says that is not similar. That Ghulam Zakaria case.
Same, it is same.
Ghulam Zakaria.
Same.
You are not similar to that.
I'm similar to that. Only thing is, yes.
Yours is not a temporary service.
No, mine was a seasonal, it was like a temporary service, 10 years, 12 years, followed by the 6 years, 7 years. I'll only request your Lordships, since these are Group D, Millard, and 4 superannuated employees, just kindly consider, Millard, so that they can, it's a question of their pension, it's a question. I'm only requesting because of their pension.
The meaning is how best we can help. You tell us this. Okay, we want to help you. See, Ghulam Zakaria, we have seen the order.
No, Ghulam Zakaria.
The High Court itself distinguishes. And you are not short. You are not short by 6 months.
No, I'm not. But then, yes, I'm not.
How do you catch up?
I'll catch up like this, Millard. In fact, if your Lordship kindly turns to page number 37. Just, Millard, your Lordship's intervention may Rule 4, Millard, if Rule 4 is.
Notice.
Yes. And my lord, I'm sorry that there was a delay. Delay was because bereavement in the family and illness. So you got it. I'm deeply obliged, my lord. I think it will help these people.
Let's see.
Item 39.
Much of it.
My lords, in this matter,
Service is incomplete, na?
Yes, your lordship. We have been trying through Dusty, but it's not done yet, your lordship.
Not fresh notices, we should return the permit.
Deeply obliged. Item 40.
Wait. I'm appearing online.
My lords, before my learned friend begins, my lords, in the last order, my lords had directed the petitioner to pay for arrears of maintenance within 10 days. My lords, till the date, this was in May. Until date, the.
Yes, Mr.
There are no arrears as on date, it's all been paid. That's my instructions. In fact, my junior is present over there, she will hand over the details.
You do one thing, you file an affidavit. Okay, now what about the main matter?
Yeah, main matter, it's only a visitation, right? Since the child is 1.5 years old, my wife, the respondent has deserted. She has not seen the light of the day, my face of the father or the grandfather. The protection officer doesn't give the report. He only narrates some incident. That is also an allegation by the wife. Based on which the appellate court, on my petition for visitation.
One minute. You see, page 40 and 53, there is an allegation that you tortured the minor.
No, that's what I want. In fact, that in the case filed by her in the Domestic Violence Act, that's the first case litigation she initiated. Not even a whisper as to this cruelty. You Lordship may kindly come to
Oh, where is the protection officer's report?
Yes, protection officer, you Lordship may kindly come to page number 40.
Yes.
In that it says, any other information regarding incidents of domestic violence against you or your child. This is a questionnaire put to the wife, in which she says the female child was kept under the Almira, in the Almira.
No, page 40.
Yes.
The protection officer says the female child.
Yes. It is not he says,
The Almira and I used to be assaulted for not giving.
Yes. Yes, this is not his statement. This is not his finding. This is the narration of allegation put forth by the wife. He only extracts it. Now, your Lordship may kindly come to rejection order at page number 53. That is the magistrate. Totally non-application of mind. Child was 1.5 years old. It again, page number 53, that's the rejection order of the custody. It appears that this court, your Lordship got it, page number 53. Middle of the page, it appears to this court that the court husband father used to inflict torture upon the minor. Not only that, he used to detain the minor by keeping him in Almira now. He again reiterates whatever the allegations of the wife. Absolutely no application of mind. The first appellate court in its order. The first appellate court, 1 second, I'll just get that. Again, it says it has examined the child and the child was crying. Obviously, the child was wanted.
Listen.
Yes.
See, page 53 is the order of the Chief Judicial Magistrate.
Yes, Mullah.
It says that the father used to inflict torture upon the minor and also used to detain the minor by keeping in the Almira.
Correct.
1 minute.
Yes.
Finally, come to page 63. This is the order passed by the appellate authority.
Correct, Mullah. 63, Mullah.
63 in the middle.
Yes, Mullah.
Page 63 in the middle.
Yes, Mullah.
Now, when this court asked the child,
yes,
what is her opinion regarding meeting her father?
Yes, Mullah.
And having sat beside this court continuously,
continuously,
she started crying.
Yes, I am very much obliged to this, Mullah.
She does not want to meet her father. She said that her father had once locked her inside the room.
Correct, Mullah. I am very much obliged to this finding, Mullah. In fact, Your Lordship, I am very much obliged, Mullah. I may only respond to this. Child was, at the time when the child was gotten away, Mullah, it was 1.5 years old. Child do not know me.
1 minute, just.
I'm sorry, Mullah.
Is her present age?
She's 8 plus.
8, so yes, 2017 she was born.
Where does she study?
It was with the mother, my lord.
My lord, she lives with the mother
Where?
in Medinipur.
Where is Medinipur?
Ma Sharda School, Damdam.
The only thing is, we put it to ourselves. One incident of having father lock the child in can will be a reason for eternity to deprive him of, deprive the child rather of the visitation, right?
But my
Father's
submission
care,
is,
love and affection.
my lord, the allegations are very serious in nature.
No, sorry.
So, my
What
lord,
is that allegation?
my lord, that he,
Allegation is that he
he
wants to
locked
her
her
up in the mirror.
no, my lord, the allegations are also about torture of the mother, increasing the volume of the TV so others cannot hear that she's being beaten up. My lord, the allegations are
We are
serious.
now into the rights of the child, not the
My lord,
mother.
my lord, my only submission is
I
that
don't
let there
want-
be my lord, appoint a child psychologist or some expert who can examine. We have no.
No, 1 minute. Can the child during when she doesn't have to miss out school come here?
Yes, my lord. That can be done.
Father, are you ready to bear the expense of the child and the mother coming to this court?
Yes, my lord. We are ready, my lord.
When
Yes, my lord.
you do one thing, just check out with the mother, give a date which is convenient to the child and the mother. We'll give that date and then let them be here.
My lord, she's in the court.
But you give us a date later on.
Yes, my lord, I will do that.
Yeah.
Very well.
Grateful.
We have to consider you that interest of justice would be best met if we were to interact with the parties as also the child. We direct, no, it's not. We then counsel are open to such situation. If the parties as also the child remain present in court on dash, then the father stroke petitioner shall bear all expense for lodging and boarding, both that of the mother and the child.
Yes. And all of the affidavit may be filed regarding areas of maintenance.
Grievance is made out that the petitioner has not cleared the areas of maintenance, which fact is disputed. Any which way, let the husband file an affidavit.
Great.
See, there is a session of this court, 2021, the file. You may also take down because the child witness, this is 2021, volume 1, SCC 414. Report is not conclusive fact. It is only because of this that we are now past.
Yes. Grateful.
Item 41.
Please, my lords, there's a prayer puja. My lords had asked me to call the respondent, my lords, the wife. They're happily married. There was a prayer puja in the council's appearing for the general letter with respect to that.
That is general
petition. It's 2 weeks. Deeply. But interim was till today. Till it says that till the deeply.
So I put to the response statement. We have not received this SLP capable copy.
42 minutes enters appearance, reply within 2 weeks to join the 1 week.
Item 43.
Because counter has not been filed by complainant.
Seeking time.
No.
They have entered appearance, so the respondent will to complain first. So just 2 times file.
You want to find 2 weeks, 1 week. Okay.
Item 44.
State election.
Yes.
See the counter of affidavit today election. I mean, based on record election. I have a photocopy of that place.
What do you say, sir, on minutes?
On merits, please, there is only very small issue. Our complaint is based on only very small issue that the school is forging the birth certificates to admit the school students earlier. It's a very simple measure. Let the state inquire and final status report.
What do you say? It is the department has to take action against in this case. There is no cognizable offence made out in this case election.
according to him, certain admissions were made. That is.
He's a disgruntled person. His child perhaps not being notification.
No, even if a disgruntled person, why do so? It is not a cognizable offence.
These are all the irregularities in the.
What irregularity?
Irregular.
Forging document, forging birth certificate is a non-cognizable offence. Which IPC you have read?
Alex, if I may answer for response 1, 2, and 3, the query.
Yes.
Alex, on page number 37 of the SLP, the impugned order that has been challenged in the High Court, in para 12, it reads, allegations made in the petition on the petitioner do not attract offences under section 420, 467, 468, 120B of the Indian Penal Code. Honorable Supreme Court and Honorable Madras High Court in several cases were decided that complaint.
Wait, what are the allegations? Read the complaint.
Yes, the allegations are not supported by any document.
There is the allegation.
Allegation. So the court says allegation do not constitute an offence under so and so.
However, forging of documents needs the documents that are forged, my lords. Those have never been produced before the magistrate.
Court is not saying. Court is not saying that allegations are not supported with documents. Court is saying that allegations do not contain a cognizable offence.
Prima facie threshold has to be met even in that case.
What threshold?
Unless
there is an inquiry by the police,
yes,
it is 156(3). Yes. He doesn't have the proof. He wants the police to investigate after registering an FIR. How do he, the complainant, private complainant, moving under 156(3), is required to file a proof? Only when it is investigated, it has to be investigated.
2 weeks.
So today it's ready. Today will.
No,
he will also file.
Yes. We have filed our counter as well.
Already filed?
Yes, ma'am.
So we can allow it today itself.
My lords, however, these are pointing against the opinion. My lords, I have a deep respect for that. But then the findings are
We'll
not.
take it after 2 weeks. Let the state.
Yes, ma'am. Yes, it's very good.
Item 45.
I think the other side also approached and said that it can be amicably resolved. This is a matrimonial dispute.
10 and 5 is calling number 2.
If it could be referred to mediation, both the parties will see.
Yes,
This is what they suggest.
Also file a counter.
Mediation by counter.
Item 46.
Deeply. But in the meantime, they should not take any coercive step.
No precipitative step shall be taken.
Deeply.
Meanwhile, no precipitative step be taken by either parties.
Was it 46? I left for the state when I was seeking a week's time to file a counter.
Counter?
I have no objection. I just have one request to make.
Yes.
He is a bank employee, the petitioner. He works for the Bank of Baroda. And he has been selected by the bank to represent their branch in Dubai. So he has to give a decision. It's all based on this matter, of course, by the month end. If it can, let him take a week's time. If I can take a week's time for the joint, may I make a request sometime before the end of August? The matter to be listed.
No problem. Okay. 1 week.
Very good. And interim orders to continue.
Item 47.
I'm okay.
Personal difficulty.
Yes, Malas, my only request is, Malas, the RM is present here as per the last order. Malas, this difficulty was on account of the senior counsel's non-availability. So Malas's appearance may be recorded because Malas directed him to be present to work out any settlement between the parties.
Is it not possible to?
Malas, some additional facts need to be brought on record. In fact, Malas, that was my next request. If I can be permitted to file an additional affidavit in this matter.
No, he was ready to pay the market price. That's what he said.
Malas, the market price, there are two main disputed issues here. One, he claims to be in possession. According to us, he's not been in possession.
Okay.
We offered him possession. He never came forward to take it.
Oh, he's not in possession?
No.
Okay.
And second issue is that he says that there is a lease deed which has been executed between the parties. We never executed a lease deed. It was just a license agreement for him to enter. So I will file all this in additional documents, Malas.
What's his name?
Malas,
Just give it in writing.
We will give it.
Present in court. Counsel submits that, Suchira submits that the petitioner, Roman 1, the petitioner was never ever in possession of the plot in question. Correct?
Yes, madam.
To Roman 2, no lease deed was ever executed
Between the parties.
Yes,
ma'am.
Then let an affidavit be filed in one week. फिर तो dismiss होगा, उनको बोल दीजिएगा.
The last date of
We
hearing.
are adjourning it today, but we are telling you this is correct. It has to be.
Let the petitioner be present on the next date of hearing because your lordship had directed the petitioner in person to
We
appear.
are, ma'am, we are, be ready. This statement is correct. Why we had sympathy with you was that you were in possession and you pay the market value. That's what it is.
So obliged.
Item 48.
Lords, we are still awaiting the report from Justice Joseph.
Okay.
Please.
See, it's in progress.
It's progress. Lordship may list it after the report is received. We'll request Justice Joseph to.
It's after, no.
No, some date has to be.
It has to be.
Otherwise, it will be in.
We'll convince.
Cannot adjourn it finally.
No, I'm.
In fact, you request the Honorable Judge.
We have requested. Lordship may have it after 6 weeks, my lord, we'll request.
6 weeks.
I'm obliged.
49.
The landlord has come before your lordships, my lord, having been given pillar to post, seeking vacant possession of his property, my lord. The High Court, my lord,
High Court in the counter affidavit, they say that you have a vacant plot and vacant accommodation.
We don't.
The counter says that.
I'll place it on record, my lord.
Their counter, see their counter.
Yes.
In counter, they have said that you have now in your possession and alternate accommodation and one vacant accommodation. That's what they say. I read it last night only.
Then.
क्या करें? What can we do? Page 6. The petitioner did not disclose at the time of the institution of the proceedings. They owned several other shops and also had vacant possession of at least one shop. Number so and so.
That aspect was the one that was considered, my lord. I'll place on record my reply there. This.
That's all right now. You better sort it out. What best can we do?
My lord,
You file rejoin. The client file here.
You
joined or you file?
I'll file my reply.
Point it out that
This matter can be sorted out. My client will even pay a higher rent.
No.
Because
he will say that he will pay money to you, you move out. Better you sort it out.
my lords can refer it to mediation. I believe there is high chance for such.
I leave it to your lordships.
Mediation?
Yes, maybe section may be sent to Alapi, my lord. The parties are based in Alapi.
Kerala High Court.
Yes. Right. In the meantime, Lord, if required, I may be permitted to file the result.
So required.
Obliged.
Mediation is awaited.
It's still awaited, my lords. Your lordships may have it after 3 weeks, my lord.
It's likely to get settled.
The drama there, why not?
Item 51.
Maybe.
This is the legal aid matter. In this case, High Court, while deciding the FAO, ignored that section 29 of the Employee Compensation Act says that if any agreement which has not been.
Who's there? Who's for the petitioner?
Sorry, I am for the petitioner. It's I'm my opponent.
Who's for the respondent? You're for the respondent.
Also, it's the finding of all the ports below.
That's all right.
That money has been paid. It's true that the provisions of sections have not been adhered to. But I mean, money has been paid. Commissioner says that it is ascertained from the evidence adduced by both the parties that money has been paid. Compensation amount has been paid. Medical aid has been given. And High Court also confirms. It's a fact that that's not registered. It's a fact.
I can read the evidence where the employee specifically denied he has received no money. I had annexed the evidence, Your Worship.
In the cross examination also, the party admits the claimant
that I have been paid the money. The written statement filed before the Honorable Commission, that is also not controverted. These things are there, my lord, but it has not been registered.
Lordship, may I read the relevant para of the evidence where he specifically denied that he has not received the money? If your Lordship permits me, I can.
Yes. This agreement at page 24 was not adhered to?
No, your Lordship.
That was not registered. But their case is, it is not registered under section 28.
Yes. My cases, and that my specifically cases, I had not received any compensation.
The employees compensation act.
I had annexed the specific provision in the appendix.
Would like to file the joint?
What is your stand?
You should my
stand means stand qua the reply, the counter.
You should my stand is they are saying that I had admitted, I have nowhere admitted. Your Lordship, I can file the rejoinder. I had filed the statement that is on page number. I had filed the statement of the employee where he specifically denied that he had not received. That is page number 32. Your Lordship, may read page number 32. 10th line, from the time till discharge, it is fact that I had approached, but he did not heed for the same. He specifically stated that the employee approached the employer for the compensation, but he did not pay anything. No written settlement has been reached. He specifically stated no written settlement has been reached. The 2829 is to protect for these agreements, because whenever the employee joins the employment, he signed on the blank paper. And he always signed on the blank paper, and these agreements are executed on blank papers, and 2829 is to protect those employees from those agreements. Your Lordship,
you may do one thing, file the journal, we keep on Tuesday.
I'll file it.
Journal for Tuesday.
52.
Hello.
52.
Yeah, please, madam. But we have filed the rejoinder also. Could my notes kindly see the provision under which the proceedings were taken up by the divisional commissioner, my notes? Could my notes kindly
the counter, they say that you admitted your mistake.
My lord, will kindly see the letter itself, my lords. We have filed it now along with the rejoinder, which is at page.
You filed a rejoinder?
Yes, yes.
Rejoinder I didn't see. Let me see.
Filed on 1st of August.
There is no rejoinder with us. There is no rejoinder. Common rejoinder?
Yes, ma'am.
What do you say in your common rejoinder?
My lord, please kindly see that letter which is referred to by the High Court and in their affidavit as page 22.
Regarding explanation for the action of demolition of the compound.
Yes. At page 24, what I say in the last paragraph, that is taken as my admission.
Notice that in this inquiry report, he is not indicted.
He's not.
It's in the okay, it's in here.
My lord has page 24 of the rejoinder. And my lords, proceedings and 80%.
Yes.
My lord, page 24, the letter starts at page 22.
Hey, 1 minute. Let us say the impugned order. What is wrong with that?
I'll show my notes. My lord, the very order which was issued, would my lords kindly see page 22 for a moment, the provision under which the divisional commissioner is proceeding against me? I placed that, my lord. Section 39(1) at page 22, my lord, of the main paper book.
Question is whether forgery was committed or not.
My lord, I have been absolved in the departmental proceedings.
But then
in both.
That does not mean. That doesn't mean that the criminal prosecution cannot be successful.
But I cannot, my lord, the divisional commissioner cannot proceed against me under 39(1). Because I cannot be proceeded because the persons against whom we can proceed is mentioned, my lord, kindly see page 22.
So that you can always say there, na? See, before the concerned magistrate, you can all take all these pleas.
We had taken before the High Court. The High Court says, no. Please see, my lord, the impugn order. Yes, so does.
Finally, come to the counter affidavit, para 11, page 5. The respondent, in the last line of that letter, the petitioner categorically admitted her mistake and apologized for the same. This clearly indicates that the petitioner has accepted her errors and she might be and sought an apology for the irregularities committed by her.
Yes, my lord. Rejoinder page 24. That is the letter which they are referring to. It says, what it says, my lord. Therefore, I request you that no action may please be initiated against me. Also forgive me if inadvertently or due to ignorance I have committed any mistake. It is not admission.
Matter of trial, it is a matter of trial.
Thank you.
My lord, he cannot proceed against me, my lord, the divisional commissioner. My lord, he can proceed only against the member of the.
Can't be fair. Thank you.
And I am not a party before the commissioner, my lords.
Thank you.
Vinchadda.
Item 53 seeking a pass over.
Also?
Also.
Fourth,
My lord, respondents have been served.
Recently, I will inspection and seeking some time to file the counter and
Counter within how much time?
4 weeks.
4 weeks.
item 55.
Plus, I am appealing for the petition matters. From last provision, man stated that the artist should in 4 weeks time to file it. Madam, has referred it to mediation. Madam, we approached them twice. Madam, the commissioner. There was no response.
It is an instruction from my client officers. But there is no letter.
Two letters twice we have.
No.
Let them again.
Who will we will send it to mediation of the
Please, madam. That would be better.
May I say something? They were employed the contractor. They were terminated in 2004. They worked for only 4 years. Equal pay for equal work. Like just 1 minute. They were not paid 45 crores. Now the tribunal has not granted them.
Today you have filed this application
It's
for
only I'll reply. I'm just. Well, this is not. I mean,
you have
very
filed this application for
we go for mediation. But this is not what the High Court has only remanded the matter to the industrial court in view of your lordship judgment. Those will have 5 tests, only in that view, the industrial tribunal has not considered the judgment of your lordship. And also, another case from Maharashtra, Kalyan Dombivli Municipal Corporation, there also, and the SLP was this way.
They are not
This. Very well, as I leave it to your lordships.
We'll grant you a judgment.
4 weeks, kindly grant me 4 weeks.
Judgment on cost.
Your lordship may refer it to mediation. Grant me 4 weeks.
Yes, I will be kindly direct as some experienced mediator will kindly give for this.
We will not say.
My lord.
You say experienced mediator.
4 weeks for counter. 4 weeks for counter.
4 weeks.
Okay.
Good. My lord.
Item 56.
Yes, please.
This matter.
Manoj, I beg to appear for the statements. I've just been served the matter, Manoj. Allow me to enter my appearance, Manoj, and file my reply.
You were watching the proceedings from the wings.
1 crore cost. The last day, he mentioned that
Now, 1 crore cost is to be paid by.
why did he not?
Because I've just been served, my lords. That is the only reason. Otherwise, have it on Friday, my lords.
How is it repugnant? I was just examining the constitutional provision. It is repugnant.
No, kindly see the provision.
Under which provision of the constitution is there?
240.
Sorry?
254 minutes.
Let's see.
254. Look at the constitution.
There's enough constitution.
Constitution. 254 minutes. Law and order, my lord, concurrent list.
2-5.
Entry 2, my lords.
Just one. No.
Straight away, sorry, my lord. Article 250 was straight away applied. And we had it.
Every state has a lokayukt.
The lokayukta matter, no?
Yes, yes,
how is it
concurrent list, my lord?
Article?
No, 254, my lord. Article 254, read with, my lord, entry 2 of list 3. If there is a subject matter which is covered by both union and the state list, and, my lords, the union has enacted a law.
One minute. 254, then list.
254 2, my lords. Article 254 2.
Correct. List
3, entry 2, my lords.
Concurrent list entry?
Lords, entry 2 minutes.
1 minute.
Yes, my lord, just read.
Criminal procedure, including all matters, including the code of criminal procedure. Correct?
Yes, my lord.
But lokayukta is not there in the.
Lord, it will be criminal procedure, my lords.
No.
Not the question will be, yes.
I just wanted to understand.
Criminal law, my lords. Kindly see 1 also.
54 2.
Yes, my lord.
And list 3.
Item 1 and 2, my lords, both.
Procedurally, substantive criminal offence.
See, honestly, when you were mentioning last time, I thought that with regard to the enactment of the Lokayukta Act, there is repugnancy.
Which enactment of Lokayukta Act itself? The Lokayukta Act is, my lords, completely repugnant to the PC Act. Completely repugnant. That's why Article 254 2 applies. The PC Act will prevail to that extent, my lord. Section.
Lokayukta is not enacting or contemplating a new offence.
No, my lords. What it
is punishing only for PC Act.
Yes, correct, my lord.
There is no offence under Lokayukta Act.
Correct. No, what I was urging, my lord, is that
why are you saying it is repugnant to PC Act?
Yes, I am saying that. Completely repugnant.
No offence.
No, my lord.
Under the Lokayukta Act,
under
no
section,
separate offence is contemplated.
Yes, Lord. Maybe I have not been able to explain.
Yes.
Section 90 of the Lokayukta Act says that investigation by the Lokayukta will go on irrespective of any provision in any other act which provides for inquiry or prior permission or sanction. To this extent, section 22, my lord, if the lordships have section 22, it's completely repugnant, my lord. Ex facie repugnant. But apart from section 22, your lordships may have.
Yeah.
Now, apart from the repugnancy point, I am on a much fundamental point, my lord. Lords, I am saying, my lord, firstly, if your lordships have my note, my lord, I can be permitted to place the note which has all my submission.
We have seen your note. We saw your note.
Yes, my lord. The first point, my lord, is that there is no permission under 17A. And, my lords, if your lordship sees the order by which, my lord, this preliminary inquiry was directed to be conducted, please have a look at page 126, my lord. Page 126 of the paper book.
The state is here today. State, what do you want to say?
Lord, may I just 2-3 things?
Milords, allow me to file a short reply, Milords, on the point. That is all I'm seeking to.
We'll give you time to file a long reply, but do file it within the stipulated time.
I will, Milords, I will.
Because we
I
don't
will.
want to
Sure.
response.
Lord, in the meanwhile, I'm praying, Lord, that the coercive proceedings at least should be stopped, Lord. Not the reason why I am saying this, Lord. If I am able to make out.
I'm not sure we are not with you.
No, Lord, kindly see, Lord, just
Then decide the issue just now only.
Lord, no difficulty, Lord, no difficulty. But may I just place my case, Lord? That is, Lord, just 2-3 things, Lord. May I leave it after that?
We have understood. We've gone through your written submission.
Yes, Lord.
See, one you say, now I've understood what you're saying. 254, entry 1 and 2, third list, repugnancy, because criminal investigation, both under PC Act as also the Lokayukta Act. That's the first thing.
No,
1 minute.
Yes, I'm sorry.
Second submission is that in any event, the Lokayukta Act is repugnant to the PC Act. That's what you're saying.
To this extent,
To this extent.
That is on the constitutionality. I'm not concerned with. Now, there is a 17A of the PC Act, which says, prior permission is required to be obtained. Now, a 3-judge bench of this honorable court says,
if suppose there is no repugnancy, sir, it is like this.
Yes, Lord.
We know that PC Act, your prior sanction is required.
Yes,
but if we come to this conclusion that Lokayukta Act and PC Act operate in a totally different field.
No, it doesn't matter even if it operates in a different field.
1 minute.
I'm sorry.
When the power of the Lokayukta and the object and the aims of the Act cannot be defeated by 17.
My Lord, I respectfully submit under our constitutional scheme, my lords. It is irrelevant, my Lord, which field it operates. As long as, my Lord, it falls under entry 1 and 2. There is no other entry, my lords, under which the Lokayukta Act can fall. Lord, I can demonstrate it right now. There is no other entry, my lords.
Under the Mizoram Act.
Under the Mizoram Act, my lord. I'm sorry.
The Mizoram Act.
Yes, my lord.
Mizoram Lokayukta.
Yes, my lord.
What are the powers of the Lokayukta?
Yes, my lord, for investigation.
And then?
Lord, investigation and then, my lord, recommending action.
That's about all.
Yes.
So Lokayukta Act is only recommendatory in nature.
I'm sorry, my lord, but investigation involves, my lord, arrest. If investigation is a matter, my lord, which is covered under the criminal law and criminal procedure, my lord, I respectfully, that's point number 1. Point number 2, my lords, I may make an endeavor to satisfy your lordships. My lord, just 2 other points, my lord, apart from the repugnance. Now, lordships have seen section 19. Now, my lords, the statute requires 2 members, my lord, to apply their mind. In this case, it is a single body member. So, therefore, my lord, the initial action
will apply.
Sorry, my lord.
Doctrine of necessity.
My lord, there was no bar, my lord, from there.
There was necessity.
Lord,
sorry.
Well, I leave that, my lord. One more point, my lord, and I leave it at that.
Yeah,
Lord, just one more point, my lord. Just one more point. Lord, just bear with me, my lord. My lord, here, no preliminary inquiry has been conducted by the Lord Lokayukta.
Thank you.
Lord, under section 19(1),
Thank you.
Lord, Lokayukta is required to conduct. Lord, should make it returnable. Lord, some returnable date may be given.
Yes.
I'm sorry, my lord.
Lord, you have dismissed.
Your lordships are asking them to call for the reply. Lordships wanted to examine this issue.
We are dismissing it.
My lord, lordships wanted to.
We examined
My lord, lordships wanted to call them. No, I'm sorry, my lord.
No.
Lord, I have not done.
We wanted to call them for a reason.
Yes.
For a purpose.
Yes.
We wanted your submission. We've gone through your submissions. One point of repugnancy was not clear to me. Now, just when I went through your submissions.
Yes, my lord.
Was not clear to me.
So then may I satisfy?
I discussed with my
Lord, may I then satisfy on repugnancy?
1 minute.
Yes, Lord.
Since
the lordships are dismissing the matter, my lord, lordships may hear me, Lord, then dismiss.
We've heard you.
My lord, kindly see on repugnancy, Lord. I think I have something to say, Lord.
Thank you.
Kindly have a look at the entries, my lord.
Thank you.
Lord,
Thank you.
my lord, kindly see, my lord. Otherwise, I would not have pushed it, my lord. It's a clean point. The High Court has not considered, my lord, on constitutionality as well, my lord.
We have gone on constitutionality. We wanted to satisfy ourselves, and therefore
I am saying, my lord, criminal law, my lord, investigation. Both are under entry 1 and 2, my lord.
Thank you.
But then may I withdraw this? May I place all this before the High Court? Because the High Court has not considered all this.
You really don't know. You want to withdraw? You will.
Lord, I will withdraw this. Lord, the Lordships are also of the opinion all these points have not been heard.
No, no. See, please understand. We found that this matter on discrepancy was there. Therefore, it enthused us. And now that we have gone through the provisions, it doesn't. And we put a pointed query to you. What is the object of the Lokayukta Act?
Yes,
it is only recommend. And what are the powers of the Lokayukta?
Including investigation, my lord.
All right. Thank you.
My lord, but then may I withdraw, my lord? May I withdraw this with liberty to, my lord, approach the High Court, my lord?
Simple withdrawal.
Lord, with liberty to approach the High Court, my lord.
Thank you.
Item 57.
Deeply obliged.
Simple withdrawal.
What is that? Lord, 57 is coming up first time after notice, Lord, I'm requesting for 2 weeks.
My lord, 16th of April, the notice was
1 minute, 15.
57 minutes.
It's a bail application, your lordship.
Not two. Let them file it.
My lord, 16th of April, the notice was issued.
See not so.
Languishing in jail, my lord. At least interim bail may be granted. Your lord.
No,
Interim bail. Eyewitnesses are there.
My lord, a case for parity, direct case for parity is there. Because has already been granted bail. And he is languishing in jail, my lord, and the state is not
Okay,
telling
now, see, we'll tell you. There are times. Come to page 57.
Yes, ma'am.
Come to page. Now, since you are, see, what to argue, when to argue, what not to argue is something which we learn only from experience. Now, since you have insisted on something, now finally come to page
57.
Correct?
Yes.
To whom bail has been granted?
My lord?
To whom bail has been granted? Name them.
Yes, your lord.
Now read first page 57, read 4 lines. Now we'll read it for you. Accused Sandesh Jadhav had caught hold of the deceased. Your Sandesh?
Yes, ma'am. Your lordship,
No, 1 minute now. Now we are dismissing your application. We are telling you.
My lord.
Why we are dismissing? We are telling you now. Accused Jadhav had caught hold of the deceased. And the other accused, Kavit Jadhav, Raju Jadhav, Sumit Chauhan, Renuka Chauhan, Santosh Chauhan, Gangabai Jadhav were given meetings to the accused with fist and kicks. Now this is Act 1. Who has been granted bail? Raju, Sumit, Renuka, Santosh. Till here, there is no difficulty. Now read the next sentence. The deceased escaped from their clutches, and while he was running away, accused Sanjay, that is meant you. So Act 1, got hold of him. Now 1 minute now. Do not interrupt us.
Yes.
You got hold of him. 6 of the accused gave beatings.
Yes.
This is Act 1. While he was escaping from the clutches and running away, now this is Act 2. Accused Sandesh, that means you, had tightly caught hold of the deceased from behind and accused Dheeraj Jadhav had strongly assaulted on the head of the deceased and shovel in his head, due to which the deceased fell down. Now, Dheeraj has been granted bail or no? No.
My lord, Sumit, my lord, I submit, man, there is a further fact. Sumit Chauhan also got hold of the disease. The sole eyewitness says that, my lord, may I show the statement of the sole eyewitness? Sumit Chauhan got hold of the disease and he has been granted bail.
Thank you.
My lord, the charge sheet as such alleges that Sumit Chauhan got hold of the disease.
Charge sheet.
Along with Sandesh Jadhav, Sumit also got hold of the disease.
We are reading you the charge sheet. Thank you.
My lord, may I show the charge sheet, your lord?
Thank you.
Just for 1 second, my lord. There are 2 accused who have got hold of the disease, my lord. In Act 2, your lordship.
Your ground is only parity. We have showed you it.
In Act 2, there is another co-accused who has got hold of the disease along with me, and that co-accused has been granted bail. After he ran, the allegation is another co-accused along with me went and got hold of the disease, my lord. And that co-accused has been granted bail. Your lordship also. There is another case to be made, my lord. The medical opinion of the doctor says that the injury has. My lord, may see the medical report of the doctor, my lord. The state cannot cause the injury on the disease on the head, your lordship.
Thank you.
Lordship, on section 34 also there is a case to be made. My lord, may see the judgment of this court. Lord, may see this judgment of this court.
No problem.
Because your lordship,
Let him file counter.
my lord, then let him file counter.
Why did you invite trouble for yourself?
Let him file counter,
I
your lord.
told you so many things.
My lord, let him file counter.
You see, don't guarantee the client for a particular day.
Lord, I have not guaranteed
Never,
my
ever guarantee a client for a particular day that today it will be done.
No. That I am not doing. My lord, I'll wait for the
He
statement.
was quietly asking for time.
Insistence for hearing without counter means something. We have also been on that side.
My lord, that was not my intention. I'll wait for the state.
You don't know your intention.
I'll wait for the state to file counter, your lord.
Recall the order. What's the
I'm
name?
obliged.
What's the name?
Digvijay Khapre, your lordship.
After we told you,
Yes, ma'am.
and in spite of that, you still insisted. So we said, come on, merits.
My lord, my only anxiety was that it's been languishing in jail for a long time and trial has begun.
What long time?
My lord says 23rd of July 2024 is in life.
24, very long time.
1 year.
302.
302.
Already. I'll wait for the state.
Yes, wait for.
Obliged, my lord. Obliged.
Recall the order. Reply within 4 weeks. Wait 2 weeks. 30 weeks आ गया कि नहीं?
Yes, my lord.
Have you understood?
Yes. I don't know.
All material instructions.
Yes.
Item
Okay, we are done again.
Yes.
4 weeks.
May please marches.
Yes.
Under 304B, his husband. Admittedly, it's a case of suicide within 1 year of about 1 year of marriage, and there were physical intimacy could not be like there was lack of it and other reasons. When she committed suicide, I informed the police. This is admitted. Then the police came and they opened the door. I mean, broke open, lowered the dead body, conducted the inquest much before the lodging of the first information report.
She received injuries also.
My lord.
It is not only ligature.
Respect, I'm coming to that.
Injuries
Kindly,
not
kindly see, my lord.
not a case of suicide.
The dupatta was also taken by in possession of the police. When what are the nature of injuries? May I place that? My lord, if you're not
Forget about nature. The moment there are antemortem injuries, then it's not a simple case of suicide.
May I?
It is 304B.
May I see? When you lower a body, where are the injuries? Kindly see. I would not say.
Shoulder, back.
This is what I'm saying. Abrasion 3 into 1.5 centimeter left side back. So this is obviously when 2%, anybody, my lord, a contusion left shoulder here. See, anybody who holds like this and lowering the dead body. And my lord, it is on my information, the police came, the GD number, Annexure 1 is the GD number. Correct, your should be very kindly have. The police arrived, the videography was done, photographs were taken, and we see, I annexed the inquest report, which was conducted at 6:37. Door was locked inside, the police found so.
Yeah.
Yes, I was told by my colleague, that's my mistake. I apologize.
He told you after hearing our conversation.
No, my lord, in fact, if I confess, my colleague had told me that you start with this and
Lord, I said, look at behalf of informant. I am putting informant.
Your party here?
Lord, I was in the Allahabad High Court.
No. Are you party here?
No, they
Lord, filed a caveat. I filed a caveat today. I am on caveat.
Caveat in 3 days party respondent of 2.
Right.
Serves notice. Reply 4 weeks, under 2 weeks. Then usual orders of the state court.
Much of this.
Item 55.
I got some after 4 weeks.
Yes, 4 weeks, 2 weeks, 6 weeks. 4 weeks for counter. We are giving it
2 weeks for rejoinder.
Return it.
some day to.
I apologize, this was my mistake.
We every day in and day out, we commit mistakes. And when we are not with either of the parties, we always commit mistakes. No?
Either from this side or from this side. We have to commit mistakes.
And by God's grace, I have got the opportunity of.
Yes, we know. Yes.
Your Lordship. Your Lordship, this particular petition is on the encroachment which is being done by street vendors and hawkers. This is a petition wherein encroachment.
You're issuing notice.
Item 60.
Operation of the operating portion will also state. It was
Court part. Court part is state.
Has to go before. We'll list it tomorrow at 1 o'clock. List before finish. Okay, 1 minute. 2. Put a bench. It's the before a bench which have passed the order dated in discipline of July 2025. List on that, add 1 point. This report shall be subject to the permission of Honorable Chiefs.
Can it be 1 o'clock?
1 o'clock, we've said 1 o'clock, but 1 o'clock means immediately
because of Senior's final disposal.
No, 1 o'clock. Honorable the permission of registered to process.
Item 61, I'm requesting for a short accommodation, my lords. I'm led by senior consultant. He is on his legs.
Oh, you are senior for us only, Colin.
Lord, may I request for password then, my lord?
Password, okay. Password are just 2, 3.
Wait, is it? Plus, the primary issue which we raised before the High Court has not been dealt by the High Court at all. Luckily, I am covered by a judgment given by a lordship just recently. We make a statement before the High Court, we are compromising. Financial statements are filed in the court of UK. Everything is settled. Financial order is passed.
1 minute. See, in that settlement but in those proceedings there, was any reference of
all Indian claims are made? Just kindly have knowledge.
I'm looking for that.
Yes, just kindly have knowledge. Kindly have page 304.
304.
And this is consequent to my making a statement.
For that clause.
Yes, I'm grateful to knowledge. Just kindly have page 304. Straightaway is right at the bottom.
1 minute. Where is that?
Just at the bottom, 1.15. Malad has that?
Invites our attention.
Then continues.
The it's our attention to what is this document?
This is a financial claim statement made before the UK court. By her.
So the document actually is 19.
Is it part of the settlement?
Yes. It is a part of our claim and page 324 in more particular. If you see 324, not only she narrates the cases, the entire money which she says during the course of dowry, etc. is given. Then you have page 324.
More particularly page
right at the bottom.
304 and
324. Right at the bottom.
24.
Money spent on wedding, my jewelry, everything.
No. Settlement of.
Yes. Right at the bottom.
That doesn't.
That mentioned Malad at page 324. Right at the bottom. She is mentioning the money spent on marriage, money spent on buying jewelry, all the claims. Then at page 325 minutes, all again on marriage. This is the FIR. And that is why we settled. And kindly have page 326, all jewelry. Just kindly have dowry. Page 4.
That's not we are.
Just see 326. That will answer your query. Just kindly have 326, 4.3. Just kindly have the page over.
The fact that I have received everything.
Yes. Amounts include expenditure on wedding function, gifts, dowry, jewelry, everything. All of that.
And what about cases in India would be settled?
Yes, Manoj. Just kindly 4.4. criminal case against India, so forth and so on. And then the kindly see the order passed. Just kindly have page 289.
We are only looking at one.
Yes, yes. Just kindly have page 289, Malad.
Who?
289, the final order at page 290, Malad. All this, and this is 290, Malad. 290. And she is the one who filed the petition. She is the one who makes the financial claim. And we settle it. There are letters of the lawyer.
Looking for that, they are not.
Yes, 290. Just kindly have 290. The parties agree. Kindly have 4 Malads introductory recital. Malads have at page 290.
ऐसा करिएगा page 289 make sure please and page 304 P90 good more specific okay. Notice notice to number 1 था introduction standing counsel.
Number 2 is presently staying in India?
No, Malad, the accused in the UK. That is why they are hounding him. The accused, the petitioner is
number 1.
Number 2.
She's
number 2.
She's now come back to India. She has come back to India. Proceedings to be stayed. Malad had already protected me in the end. Great. Great for this.
Clean profit only.
Yes, but exorbitant loss. I'm not.
What is exorbitant? 1,200 rupees for 12,000 per month.
12,000 loss. I placed on record loss by way of exemplary loss release dates.
You vacate, we'll give up area.
She's a kindly singer. This is the only means of livelihood that I have.
For settlement, we can issue notice, not otherwise.
Your Lordship, you should notice.
Or you vacate, we will reduce you to 10,000.
Plus, all I'm requesting is, I've placed by way of additional documents, 6 samples these details, which say that the rent in that area
is enough.
Well, only for compromise,
only for settlement.
Settlement.
So only issue notice only
for settlement.
For exploring the possibilities.
I'm grateful, deeply grateful.
You were best in vacate and
no, I don't have any other source of.
He'll give you money, he'll see something.
I'm grateful, deeply grateful.
Pass over 3.
Yes, sir. Allowed.
One was when we see the drugs were, one was in commercial quantity, they were banned drugs. Also, he's the owner of the transport company who is transferring it from Delhi to Behroon.
He's been in custody from July 24.
Pass over 53.
The last hearing orders what I have filed in a affidavit. Issue related to the pathway, Millard.
Pathway is not convenient.
Can you see the map?
Mr. Nagmuthu.
I tried not. I want the parties to come. I tried to budget, but they have their own reasons. It's very difficult to accept this.
Why? He's giving you from his own land.
No, the issue was would not be convenient at all. No, they cannot use it at all.
Is it so?
I'm also convinced of that.
Oh, if Mr. Nagmuthu is convinced, then sorry.
If he is convinced that there is no way, then there is no way.
Thank you. Thank you.
Dispute is about way only, and if he says no way.
The one chance can kindly see us. We want to pathway in middle of the way.
If Mr. Nagmuthu says no way, himself says no way, thank you, no way.
Giving the personal land.
Thank you.
Kindly.
Thank you.
Last hearing also, not cleared on merits, Millard.
No. We were only on exploring the settlement.
Kindly see the map or my satisfaction.
I have seen the map. एक मिनट दिखाना. एक मिनट file दीजिएगा.
The color map, Millard, which I have filed it.
Yes.
The middle of the road he is asking.
This is the map.
Yes, Millard. Middle of the road. I'm ready to give more than that, what actually I should be.
We have seen the map ourselves.
But orange portion, but I'm ready to give more than that. What actually 12 feet is 250 feet, 12 feet deep, 250 the length they are claiming. But I'm ready to give 16 feet deep and 290 feet length.
We cannot tell portion. Thank you.
Okay.
Pass over 61.
Wait, please. There are two things the court do not consider at all. Now, this was a suit for specific performance. The agreement said you have to pay it in 3 months. Now, he doesn't pay it in 3 months. I issue a notice, give him 1 week's time. You give in next week 1 week. He still doesn't give it. He replies, says that I can't give it. Please have a look at that. But first, Your Lordship, may please see the agreement at page 28.
28, come to 28. Where is the
Yes.
timely sense of the contract?
Yes, I'll show that.
Please show us.
Please.
Remaining amount to be paid as follows.
Yes. Please see page 31, paragraph 5.
Within 3 months.
Yes, within.
Then
So it says within. Now, Your Lordship,
doesn't make it timely sense of the contract.
Your Lordship, may please see page 41, 43.
Ah.
This is a notice I give. And please have a look at page number 45.
Yes.
Bottom.
Yes.
Now, I asked for 47 lakhs alone. 57 lakhs was the consideration. 10 lakhs he pays an earnest amount. 47 lakhs is the leftover money. Para D, the remaining amount of 47 lakhs was to be paid by you to a client personally by DD check within 3 months. You had agreed and promised to pay the fixed amount of 57 lakhs.
Now, can't you see?
No, one more paragraph.
Page 58 is his response.
That's what, please see page 46. What I asked for is 47 lakhs. Now his response. Yes, I wanted to show that. Paragraph page 58. Now Your Lordship may see page 59. What does he say? That you are asking for 30 lakhs more. Where am I asking? My notice says give me for 47 lakh balance.
Gentlemen, can you come to page 60? He says our client is fully ready to complete his transaction.
See page 59. What he says.
There is no deliberate or intentional delay on our part.
Please have a look at page 59. What he says is this, page 59. Please have a look at page 59. He was never really willing to perform his part of contract.
He decreed by the trial court?
Yes, my lord. And now please see page 59.
Already deposited the remaining.
So when now?
In 2003, my lord. 23 also deposited, my lord.
After
the
3
remaining
years,
amount in the court, my lord. In persons of the
2021 agreement, after 3 years, my lord, he deposited. And please have a look at page 59. What a lame excuse he gives for not depositing. Please see page 59.
Thank you, sir.
Please see page 59. That what a lame excuse he gives. He says that you are demanding 30 lakhs more. Your mind notice says 47 lakhs.
Thank you, sir.
With all humility at my command, may I mention a matter that was listed on Friday. My lord, I had very clearly heard that notice has been issued. Therefore, I had not argued on sentence, but on bail, item 39. But on the net, it is showing disposed of.
No, we do not remember the case.
It was Pintu versus State of Chhattisgarh. It was an NDPS matter.
NDPS, we have dismissed it.
My lord, I
wrongly heard it. We have dismissed.
Clearly heard notice. Therefore, I not even argued on sentence. Maximum sentence.
It was dismissed.
My lord, maximum sentence has been awarded for the first time offender who was 25 and handicapped.
Yeah, handicapped. Yes, I remember that handicapped person.
Yes, my lord.
I made that comment also. These days,
yes,
dons are
that was
engaging all.
That was on bail, my lord.
It was sponsored decision.
We are very clear. We remember. Our memory doesn't fail us. We have dismissed it.
My lord, it must be my mistake then when your lordship are also saying, but I
no, if you are
argue on the sentence.
If you committed a mistake in hearing, we will not recall the order.
Thank you.
Why should we recall the order?
I'm not saying, I'm not requesting also when it was so.
Thank you.